appeal.
Yes, jail appeal
This is
coming
jail
up for the
appeal.
first time.
This is a jail appeal challenging the judgment dated 31/10/22 passed by the Sessions Court Biswanath, Biswanath Chairadi in Sessions case number 106/2019, by which the convict has been, by which the appellant has been convicted under section 302 IPC. So the appellant has further been sentenced to undergo rigorous imprisonment for life and to pay fine of rupees 5,000, in default rigorous imprisonment for 1 month. By sentence order dated, where is this? 4/11/22. Admit the appeal or what?
Lordship,
Admit the appeal.
records.
Call for the LCR. Do we appoint?
Amicus.
Who do we appoint?
There is a list.
You,
Mr. Dhar is there.
Mr.
Dhar.
Mr. Edhar.
His name is there in the list.
Okay, Mr. Edhar is appointed as amicus curiae.
Perhaps it's a 302 matter, so informant is not.
No, list the matter after receipt of the LCR.
Lodge.
His lordship. Is an appeal under section
So we
370.
admit the appeal. Heard Mr. S.G. Purkaisa, learned counsel for the appellant, who submits that the judgment dated 15/12/22 passed by the special judge Pokso, Kachar, in special Pokso case number 48 of 2020 should be set aside. The appellant in this case has been convicted under section.
No, lordship, this is against acquittal 372 by the
This-
By the victim.
Actually, you're the victim.
yes.
The challenge is made by the victim,
Informant.
by the informant, against the acquittal of the accused. Respondent number bracket.
Respondent number 1.
2. Oh,
Yes, one.
oh, 1. Dinesh.
Respondent number
Ramos.
1.
1.
Issue notice returnable in 4 weeks. Ms. S. Jahan, additional PPXF notice on behalf of respondent number
2.
2. Appellant to take steps for service of notice upon the respondent number 1 within 2 days, 3 days. Do we call for the LCR? No.
If your lordship has admitted, your lordship can.
Have
call
we
for
we have not admitted?
It may be admitted because leave is not required, lordship.
Okay. Admit the appeal, call for the LCR.
the- Not.
List the matter after 4 weeks.
Lordship, judgment is dated 15/12/2020.
Judgment is 15/12/2020.
2020. That's
Mid-page lordship, appeal against conviction, my lord. The appellants in conviction. under
Okay,
section
right. Heard Mr.
R.S. Mishra.
R.S. Mishra, learned counsel for the appellant, who submits that the judgment dated 5/12/2022 convicting the appellant. No, passed by the court of the additional sessions judge, Dibrugarh, in sessions case number 164/2013, convicting the appellant under section
302
302 IPC
and my lord 498 AIPC.
and
There are 2 sections, my lord. 302 for life, my lord, and 498A for 2 years, my lord.
and 498A of the,
IPC.
IPC.
of the
IPC.
IPC can be set aside. Admit the appeal, call for the LCR. Miss S. Jahan, additional PP appears for the state. List the matter after receipt of the LCR.
There is an IM, my lord. My IM will be considered
yes.
on receipt of LCR, my lord.
And I'll file my objection in the
Okay, right,
meantime.
in the IA, you write, Miss S. Jahan, additional PP is granted
2 weeks.
2 weeks time to file written objection. The matter will be heard after receipt of the LCR.
Oblige, my lord.
My lord, I am appearing as an amicus in this matter.
So the paper book has to be made.
Yes.
That's all.
LCR is here.
LCR
Okay.
is received.
Lodge.
Right, right. The counsels for the parties are present as LCR has arrived. Registry to prepare the paper book and furnish copies of the same to the parties.
Obliged.
List the matter after preparation of paper book. What is to be done, madam, for
Your
hearing?
paper book is ready. Yes,
Have
for
you been
hearing.
given a copy of the paper book?
Yeah, but my lord, actually, my senior is nearby the court, so kindly pass over typing.
You go and ask your senior if paper book copy has been given to him or not. Okay, then you come back.
Yeah, for the informant, no? Oh, accused. Acquittal. 6-2, yeah?
May please your lordship. The paper books has been received, my lord.
So,
And my lord, as per the office note dated 13/2, notice was issued to the respondent number 2. The remark has been noted that he expired, my lord. The notice has-
addressee expired.
My lord.
Not required.
So we'll list for hearing or you want to
We'll
hear it straight away?
Hearing, my lord.
Hearing.
Right, the counsels for the parties are present and they submit that they have received copies of the paper book. So, sir, in respect of the respondent number 2, office note dated 13/2/2023 states that the addressee has expired. So, sir, in that view of the matter, notice is complete against the all the in that view of the matter can be heard. It can be listed for hearing.
Hearing.
Accordingly, list this matter for hearing in usual course.
No. Oblige.
May I please your lordship, my lord. As per office noted dated 8/2/2023, my lord. Service is awaited. We have taken steps, my lord. Upon the private respondent number 2.
Notice issued on 1/12
1/12/22.
and till now no service
Service is
report.
awaited, my lord. No
Now
report has
what is to
They'll
be
take
done?
fresh steps, they say. They'll take fresh steps.
My lord, already 1/12, my lord.
I know.
Service is
2 months
awaited in after 4 weeks.
Huh?
After 4 weeks, my lord. Service is awaited.
No. That is a different issue. What about your, okay, now that is the problem. Now what to do? Do we issue fresh notice or what?
1/12/2022.
Okay, right. The learned counsel for the appellant and Ms. B. Buyan, additional PP are present. Notice was issued to the respondent number 2 on 1/12/2022. So, however, there is no service report even after the expiry of more than 2.5 months. Appellant to take fresh steps for service of notice upon the respondent number 2 within 3 days. List the matter after 4 weeks. Then what about the IA?
My lord, for bail.
Give me the IA.
my lord, senior.
The
My lord, I may
objection is here.
be taken up in next week.
No, we
next
can take it up
after-
now. Just tell us. We cannot keep it pending. Just tell us. What is the facts of the case?
My lord, my senior is in another court, my lord. My lord.
Who's the senior?
Yanuddin, my lord.
What is your name?
Yam Islam, my lord.
Your name is there also. You tell us.
My lord, after service completed, my lord.
Service is a different thing. Out here, the I is ready for hearing.
I come up after 4 weeks, my lord.
No. Why?
Then, my lord, after some time, my lord, my senior is in another.
After some time.
Someone
My lordship. I'm appearing as amicus lordship. LCR has been received. To prepare.
Okay, Mr.
SD
Yes.
Purkasta.
S.D. Purkasta appears for the appellant. While Ms. Biboyan, additional appears for the state. As LCR has arrived at registry to make the paper book and furnish copies of the paper book. Then in terms of the office notes dated 6/2/2023, there is no return of any card or unserved notice from the respondent number 2 bracket informant, despite issuance of notice on 16/2/2022.
objection.
16/2.
No, it's 22.
Flush.
22.
16 to 52 and today is 17 to okay.
2022, I think.
PTA. Jana कैसा PTA?
Bit wrong. This is 16 to 16/12/2020. What to do?
Oh, PTA also steps.
1612.
Let's just list the matter after preparation of paperwork.
Obliged, lordship.
Which will be next?
I'm appearing on behalf of amicus.
You are appearing on behalf of
I'm appearing as an amicus, correct?
your BN Gogoi.
Yes, lordship.
Okay, right.
LC has been received. as per
LCR
the call.
will sit, right. Counsels for the parties are present. As LCR has arrived, the registry to prepare the paperwork. This is the matter after
Preparation of paper.
preparation of paperwork.
Lordship, may I plead the lordship? Lordship, the case is otherwise for bail, my lord, for hearing of the bail. My lord, may I pray, my lord, can the matter be taken after some time, my lord? For the time being, it may be adjourned.
For the time being,
For the time being, lordship.
okay, but you be here.
Deeply.
May I plead the lordship? Item
Go on.
13 may be passed for time being.
13 was not even called. You know. Oh,
Yes, for you have for
For 13 lordship.
13. So what do you want? You're ready? Give us item 13.
13. Yes. I don't think so. I've given no objection. Is it?
We have filed I for implementing of party lordship.
So Jasmine,
What happened in this case lordship, the informant compromise with the accused petitioner lordship. Appellant. He is not appear before the court lordship because in accused petitioner is the own brother of informant lordship. That's why mother of the accused, mother of the victim,
Accused petitioner is the,
brother of informant, lordship, own brother of informant.
and who is the informant?
Informant is the brother of the accused.
So
But
they have writ-
I am the mother of the victim, lordship.
Impleading as such in criminal matters are not
Where is
required, but,
Lordship,
and state is there to defend.
No, wait a minute. Let us be very clear. Who is this applicant who wants to be impleaded?
Applicant is he, no,
yes, the
applicant is he.
lordship, applicant is the mother of the victim, lordship.
Applicant,
Is the mother of the victim.
mother of victim.
Big
Huh.
victim,
Is
lordship.
who is the informant?
Informant is the brother-in-law of
Victim.
victim's
Is brother-in-law of victim.
uncle of victim, lordship.
Informant is uncle of victim.
Uncle of victim, lordship.
Sorry.
Uncle of victim. So in this appeal, so you are, who are you? You are the appellant.
I am the mother of the victim, lordship.
Okay, first of all, who is the appellant?
On the,
Huh?
on,
You are the appellant. You have been convicted. Yeah, and
on the last.
and who is the informant is not present, correct? Informant is not here.
They have reached to some kind of a settlement. Is it?
No, anyway, wait a minute. So, appellant has filed the appeal
Hmm.
against the state
Yes.
and against the informant.
Against the conviction, yes.
Yes. So, informant is the uncle of the victim who is not here in the court today.
Yes, lordship.
Now, you are the mother of the victim
I am the mother of the victim.
and you want to come to the, what ground? You've got no locus standi to come.
On the
You're
last
not,
occasion.
you're
of
neither the
course,
victim, neither the informant.
Lordship, informant mutually compromise with the lordship, appellant, lordship.
So,
he was supposed to find some decisions. On
He
the
is not,
last occasion.
he is not appearing before the court, lordship.
who is
Notice
not
of issue.
appearing? The informant, you mean?
He is no longer pursuing against the accused. He is saying.
Kindly peruse the last order, Lordship, on 25/1/23.
We were supposed to find out some decisions on that.
No, there is no case. You see, the question of, there's a difference between the informant and the victim.
Hmm,
All informants need not be the victim.
hmm,
Okay. Notice has to go only to the victim, nobody else.
hmm,
Informant may be anybody,
hmm,
but if it's not the victim,
hmm.
then it's not required.
Not required.
Not required. Notice has to go to the victim, basically.
Huh.
The
We are
victim has
there.
got the participatory rights, not the informant as
Hmm.
such.
Yes, lordship. And I am the victim, lordship.
So if
the
that is the
victim's
case,
mother.
who are
Victim's
you?
mother.
Yes. Yes.
Who are you?
I'm
No
there,
case.
why they are.
No case.
Lordship, we find on judgment, lordship.
Okay, let us.
It's lordship own judgment, lordship.
Mine
Own
is-
order. Yes, lordship.
Has to be in a criminal matter. Criminal? matter?
Criminal appeal 205/2018, lordship. Kindly do. There are 8, lordship.
Mortifying. Here informant is,
That is a
here
different
not
issue.
required.
Yes. What does it say? What? Read out. Where is the relevant portion?
This is not mandatory, Lordship. This is obligatory, Lordship.
Lordship, section 302(1), middle of the 8,
Yeah.
lordship.
Yes.
There are 8, middle of the 8, lordship.
Yeah.
302(1), and the public prosecutor in the provision to section 24(8) CRPC makes it abundantly clear that the right of the victim or any other private party to participate in the prosecution of criminal case.
In
Or
the
prosecute.
prosecution. You want to prosecute, that's a different thing. You see, anything that you want, you can always give it to the prosecution.
Lordship, my humble prayer is that Lordship kindly allow me to participate.
Why? What do you want to say? What do you want to say before this court? Well, if we allow you to participate, what are you going to say? What is your submission going to be? Supposing we have allowed, assuming we have allowed. Now, what is your next step?
Next question, Lordship.
Cannot be allowed to participate just for participation's sake. It does not mean that every Tom, Dick and Harry will be allowed. Now you are the mother of the victim. Tomorrow the father will come, sister will come, brother will come. Only then what happens? So what are you going to say when if supposing we allow your application?
Under section 301.
Kindly Lordship, one more date. One chance, last chance, Lordship.
For what?
My senior.
Yes, madam, what have you got to say?
Otherwise, of course, I did not bring the judgment, but High Court, I have found Bombay High Court saying that in pleading in criminal appeal by the informant is not provided for under the CRPC.
Applicant is not the informant also.
Yes, not
He's
even
got
in-
no role to play. He's not the victim, not the informant.
The term victim as defined under CRPC includes those mother, father, any heir.
Huh?
I think 2J or 2A.
No.
2WA.
2WA.
2WA, Lordship can see CRPC. Victim includes 2W. I'll just read out. 2WA, victim means a person, your Lordship got. Victim means a person who has suffered any loss or injury caused by reason of the act or omission for which the accused person has been charged, and the expression victim includes his or her guardian or legal heir. That, of course, is included. But impleading of an informant is also not provided for under the CRPC. This victim definition would be relevant in context of section 372, where victim comes in an appeal against acquittal. But as far as in the conviction matter, impleadment in the High Court in appeal is not provided for. This is what the High Court said. Supreme Court, I have to find some decisions. No.
This is a POXO case?
No,
No,
Lordship.
302.
302, Lordship.
Then
And at best, under 301, they will just assist and file a written argument with your permissions, Lordship's permissions.
heard, Mr.
A. Alim Sheikh, Lordship.
Your name is not here.
Yes, Lordship. On behalf of Mr. M.U. Mondal.
A. Alim Sheikh, appearing on behalf of Mr. M.U. Mondal, learned counsel for the applicant. Praise that the applicant, who is the mother of the victim, should be impleaded as respondent number 3 in the appeal filed by the appellant convict. Miss S. Jahan, additional PP, appears for the state while Mr.
Yeah.
A. Ahmed
Yes.
Appears for?
For the appellants.
appears for the appellant,
Appellant.
appellant/convict. So, sir. No notice was issued to anybody else, correct? No notice was issued to
Notice
anybody.
is to informant, no.
In main appeal,
Informant?
notice was issued to the informant.
In the informant, okay. Then what has happened in the, give me the name.
That is served, but he did not.
Appear.
Okay, right.
Notice is served.
No one appears for the informant, though notice has been issued to the informant. And this court, by order dated 23/2/2021, had held that service of notice on the respondent number 2 was complete. The counsel for the applicant submits that the informant is the uncle of the victim, while the applicant is the mother of the victim. You don't know why, you don't know why the applicant should be impleaded. No reason. What is the reason given in the application? The reason for the applicant counsel submits that the respondent number 2 that is the appellant has cannot be. What are you writing? Opposite party number 2 out here is who? Mustafizur Rahman. Who is he?
Mustafizur Rahman.
Who is he?
Mustafizur Rahman is the lordship uncle of the
Uncle.
victim lordship.
The counsel for the applicant submits that the informant has entered into a compromise with the appellant and as such is not appearing before this court despite issuance of notice. He submits that the applicant, who is the mother of the victim, should be allowed to appear as a respondent or else the applicant would suffer irreparable loss, hardship, and injustice. So, sir. That's all. Next para. Miss S. Jahan, the learned additional PP, on the other hand, submits that there is no provision for impleadment of a third party in an appeal in a criminal case. She also submits that the interest of the parties would be taken care of by the state, and the only role that the applicant could have is to assist the prosecution. That's all. What about you? What have you got to say? Have you entered into any?
My submission is same with PP lordship. They can assist the PP, but they cannot implead in the.
No, the question is, have you entered into any agreement with the?
Not he.
Huh? No,
But
mutually, how are you going to prove mutually? This is not a civil
lordship
court.
informant is the own brother of the
Huh?
own brother of accused lordship informant.
Who?
Mustafizur Rahman.
The informant is the own brother of the
Uncle Colorado.
You said uncle.
Informant is the uncle of the victim, lordship,
Ah,
but
he's the brother of the accused.
he is the brother of accused, lordship. Own brother of accused.
And she is my sister-in-law.
Yes, lordship.
Okay, right. The counsel for the appellant slash convict submits that the appellant, that the informant is the brother of the appellant and the sister-in-law. No, and the brother and the brother-in-law of the
Appellant is her brother-in-law.
married to whom? Which one of you married to whom?
We have three brothers.
Okay, married to the third brother.
Third brother.
Okay, okay. So what have I said? A brother of the appellant and the brother-in-law of the deceased victim. Correct?
Yes.
Brother-in-law of the
Victim.
applicant.
Applicant.
Brother of the
The
informant.
informant is the brother-in-law of the applicant and the brother-in-law of the.
Brother of the informant.
Wait, let me see you. Let me just read it. Applicant, the informant is the brother of the applicant and the brother-in-law of the deceased victim. Full stop. He submits that the appellant, the applicant, and the husband of the deceased victim, namely husband of the deceased victim.
No, victim is lordship son of the applicant.
Victim is a girl. No,
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 boy.
oh, victim is not.
Boy, minor boy.
Son of
okay.
the applicant.
Yes.
Okay, and the victim and deceased victim are all brothers. They are all brothers. Correct.
All brothers.
So that the woman is also not a victim.
She is not alone.
Uh-huh.
She's not a victim also. If the person who died is the brother, only the brother died.
Son of the applicant died.
Son of the applicant died, lordship. Lordship,
Correct, son of the applicant.
appellant, lordship, appellant, informant. Both are the brother, lordship. And lordship, they are the three brothers, lordship. One is Ziaur Rahman, appellant, and informant, and another is one, lordship. And in I, lordship, Jasminara Begum.
Huh?
Jasminara Bibi, in I, lordship, applicant. Applicant marry the third brother, lordship. They are the three brothers, lordship.
Applicant cannot marry the third brother. Applicant is the mother of the victim, mother of the. Acha, is the
Yes,
mother
Lord.
of the victim.
Yes, lordship.
Victim is my niece, my nephew, sorry, my nephew.
It's all more convenient.
Okay, applicant is the mother of the victim.
Victim.
Okay, the victim is your brother. No, applicant is the mother. You are the brother of the victim.
I am brother of the informant. And brother of.
We are the
husband
brother of the
applicant.
informant and
Brother of the.
brother of
applicant's
the.
husband.
Huh?
Brother of applicant's husband.
Brother of applicant.
Yes. And victim is my nephew.
Please do talk about this.
Okay, I'll figure that out later. I'll correct it. Right. So we'll pass. It's rejected. Okay. Ms. Jahan, I think you have to come later on. We'll pass the order later.
Lordship, this is a condemnation of delay application, delay of 604 days in preferring the appeal by the state. On the last occasion, your lordship, lordship is not in our favor, your lordship, because there's delay, unexplained delay of 7 years.
7 years delay. Yes.
Just I wanted to place two judgments of
Yes,
Honorable
yes.
Supreme
Yes,
Court.
please.
2000. Excuse me. 2010 14 SCC 419. Indian Oil Corporation Limited and others versus Subrata Bora, Chow Lake and others.
2010 14 SEC.
14 SCC 419.
Yes.
Para 5, your lordship. As stated above, the appellants have pleaded that the delay in filing the appeal was unintentional and bona fide in as much as on receiving an uncertified copy of the judgment, they sought legal opinion from their local lawyer on 7509, which is received by them on 21509. Thereafter, the same was forwarded to the General Manager HR Refinery Headquarters, New Delhi on 28/5/2009. By this later, it is so and so. The said general manager sought some documents, including a certified copy of the judgment. Subsequently, the general manager forwarded a case file to the company's legal advisors at New Delhi on 18/6/2009. The said legal advisors gave their opinion on 7/7/2009, advising the appellants to file an appeal against the judgment of the single judge. The proposal was approved by the headquarters of the appellants, whereafter the case file was handed over to the council for preparing and filing the appeal, which is ultimately filed on 21/7/09. Having heard the learned counsel, we are of the opinion that in instant cases sufficient cause had been made out for condemnation of delay in filing the appeal, and therefore the High Court erred in declining to condemn the same. It is true that even upon showing the sufficient cause, a party is not entitled to the condemnation of delay as a matter of right. Yet it is tried that in construing sufficient cause, the courts generally follow a liberal approach, particularly when no negligence, inaction, or malafidis can be imputed to the party. Para 7. In Ramlal versus Rewa Coalfields Limited, this court held that in construing Section 5, it is relevant to bear in mind two important considerations. The first consideration is that the expiration of the period of limitation prescribed for making an appeal give rise to a right in favor of the decree holder to treat the decree as binding between the parties. In other words, when the period of limitation prescribed has expired, the decree holder has obtained a benefit under the law of limitation to treat the decree as beyond challenge. And this legal right, which has accrued to the decree holder by lapse of time, should not be lightheartedly disturbed. The other consideration which cannot be ignored is that if sufficient cause for excusing delays shown, discretion is given to the court to condone delay and admit the appeal. This discretion has been deliberately conferred on the court in order that judicial power and discretion in that behalf should be exercised to advance substantial justice. As has been observed by the Madras High Court in Krishna versus Chattappan, Section 5 gives the court a discretion which in respect of jurisdiction is to be exercised in the way in a judicial power and discretion or to be exercised upon principles which are well understood. The word sufficient cause receiving a liberal construction so as to advance substantial justice when no negligence nor inaction nor want or bona fide is imputable to the appellant. Similar next para your lordship para 8. Similarly, in Ramnath Sao versus Govardhan Sao, the court observed that, but one thing is clear, that the court should not proceed with tendency of finding fault with the cause shown and reject the petition by Sleaford order in overjubilation of disposal drive. Acceptance or explanation furnished should be the rule and refusal. An exception, more so when no negligence, inaction, or want of bona fides can be imputed to the defaulting party. On the other hand, while considering the matter, the court should not lose sight of the fact that by not taking steps with the time prescribed, available right has accrued to the other party, which should not be lightly defeated by condemning the delay in a routine-like manner. However, by taking a pedantic and hyper-technical view of the matter, the explanation furnished should not be rejected when stakes are high and arguable points of facts and law are involved in the case, causing enormous loss and irreparable injury to the party against whom the lease terminates either by default or inaction, and defeating valuable rights of such a party to have the decision on merit. While considering the matter, courts have to strike a balance between result and effect of the order. It is going to pass upon the parties either way. In State and City of Delhi versus Ahmed Jan, while observing that although no special indulgence can be shown to the government, with in clear circumstances is not shown to an individual suitor, one cannot but take practical view of the working of the government without being unduly indulgent to the slow motion of his wills. Highlighted the following observation of this court in State of Nagaland versus Lipak Ao. It is axiomatic that decisions are taken by the officers, agencies, proverbially at a slow pace and encumbered process of pushing the files from table to table and keeping it on a table of considerable time causing delay, intentional or otherwise, is a routine. Considerable delay in procedural rate tap in the process of their making decision is a common feature. Therefore, certain amount of latitude is not impermissible. If the appeals brought by the state are laws for which default, no person is individually affected, but what in the ultimate analysis suffers is public interest. The expression sufficient cause should therefore be considered with pragmatic in a justice-oriented approach rather than the technical direction of the sufficient cause for explanation, explaining every day's delay. The factors which are peculiar to an characteristic of the functioning of the government condition would be cognizant to and request adoption of pragmatic approach in justifiable oriented process. Para 10, it is manifest that though Section 5 limitation in 1963 emphasizes the explanation delay to the satisfaction of the court and makes no distinction between the state and the citizens, that nonetheless, adoption of a strict standard of proof in case of government, this is dependent on the actions of its officers, who often do not have any personal interest in its transaction, may lead to great miscarriage of justice, and therefore certain amount of latitude is permissible in such cases. So my contention is that if your lordship doesn't condone the delay, it will adversely affect the rights of the party who is a lordship, who is of the litigant. Your lordship will not be affected. We are appearing on behalf of the victim, your lordship, who is it about 13 years and who allegation of rape was there by her employer. So your lordship, in that view of the matter, taking into account that serious miscarriage of justice will be done to her if your lordship doesn't allow.
What will be the miscarriage of justice?
Miscarriage of justice in the sense, the lordship, the learned trial court did not take into account the relevant factors. Lordship, that she was the injury was on her part, your lordship, on the part of the victim girl, your lordship. Doctor has opined, your lordship. In the merit, we have a very good case, your lordship. Just because there are little bit of inconsistencies here and there in a 164 statement, as well as in substantial evidence, your lordship. So lordship, the learned trial court below, your lordship, overlooked that aspect, your lordship, and allowed the appeal. Lordship allowed the case in favor of the respondent, your lordship.
That's all. And what about the other judgment? Anything else?
2010 5 SCC 459.
No need. Same thing.
14 to 16. That
You had given something.
Firstly, the explanation, the whole burden has been given on the prosecution under the law, the rules. The public prosecutor doesn't have any role, with regard to the filing of an appeal. I have the other day also, I have shown the police manual section.
Just show us again. Just show us again.
Rule 27.
Yes.
Plus sub paragraph. in case of acquittal, where there has been a grave miscarriage of justice and the superintendent of police thinks that an appeal is necessary and is likely to be successful, he is with the least possible delay, send the district magistrate a full note on the case so as to enable that officer to move the local government to appeal to the High Court under Section 417 CRPC. It should be noted that as a matter of practice, the local government declines to appeal against an order of acquittal unless moved to do so within a period of less than 3 months from the date of the order. Hence, need for prompt action.
What is this? Assam Police Manual.
Lordship, my lord, it is under this, my lord, the police, the superintendent is vested with the, my lord, duty to scrutinize or the watch or the, my lord, see that, my lord, the prosecution before the, my lord, magistrate or the session court goes in a proper way and helps the, my lord, the court and the public prosecutor for, my lord, proper, my lord, trial of the case. And in case, my lord, this, my lord, he is acquitted, the accused is acquitted. In that case, my lord, he has to make a report to the district magistrate, who will then, my lord, if you need the opinion that there is a miscarriage of justice or, my lord, there is a very reason for successfully, my lord, holding the appeal.
So this is only a guideline.
But public, here what they have been saying, it is the public prosecutor has sent after 7 days. What duty he has, my lord? He doesn't have any duty. It is
The public prosecutor has?
Their explanation is that, my lord, the public prosecutor has, my lord, sent the judgments after 7 years. My lord, paragraph 3, my lord, of the application.
They have not said that.
That the request of preferring an appeal against the said judgment, my lord, that the request for preferring an appeal against the said judgment dated 29/9/2010 was received by the office of the public prosecutor.
Correct. It was received by the office of the public prosecutor.
Lordship, yes, public prosecutor from the office of the LR Commissioner and Secretary to the Government of Assam in the month of December.
Correct.
As some of the pages of the judgment was missing and as no explanation regarding the delay was forwarded to us, accordingly, same was intimated to the LR Commissioner.
So why should we go into this issue?
No, my lord, no, here you are
This
subsequently, my lord. The request for preferring an appeal against the said judgment dated 29/9/2010 from the present public prosecutor of Morrigaon district has been received by the office of the LR Commissioner and Secretary to the Government of Assam only on 13/12/2017. It is the public prosecutor of Morrigaon. From him, my lord, request for, my lord, appeal was my lord, placed before the LR Commissioner only on, my lord, December 2017. So thereafter, my lord, the LR has sent to the public prosecutor of the, my lord, High Court and then, my lord, rest of the issue. So, my lord, my whole submission that the explanation.
So your case is basically besides the non-explanation for the delay, the decision by the public prosecutor in December 2017 for filing an appeal is not in consonance with the Assam police.
They have to explain that the superintendent police has reported on so and so date, and thereafter with the consultation of public prosecutor.
Anything else?
That is one, my lord. And secondly, my lord, I have given a judgment of the 2012 Supreme Court 1506. Perhaps the record is there.
2000, I have taken it somewhere.
But the other day I have submitted the
I know. I think it's in my chamber somewhere.
Well, I'll just read out paragraph 13 and 14.
Paragraph 13 and 14, yes. Read. 2012, what is the citation? AIR.
AIR, paragraph 12 and 13. AIR 2012 Supreme Court 1506. That is subsequent to the judgment cited by my friend.
Yes.
Married.
This is.
This judgment.
There was an insect running around here. That's why.
Well, I'll just. It is not in dispute that the persons concerned were well aware or conversant with the issue involved, including the prescribed period of limitation for taking up the matter by way of filing a special leave petition in this court. They cannot claim that they have a separate period of limitation when the department was possessed with competent person familiar with court proceeding. In the absence of plausible and acceptable explanation, we are posing a question why the delay is to be condoned mechanically merely because the government or a wing of government is a party before us. Though we are conscious of the fact that in a matter of condonation of delay, when there was no gross negligence or deliberate inaction or lack of bona fide, a liberal concession has to be adopted to advance substantial justice. We are of the view that in the fact and circumstances, the department cannot take advantage of various earlier decisions that claim on account of impersonal machinery and inherited bureaucratic methodology of making several notes cannot be accepted in view of modern technologies being used and available. The law of limitation undoubtedly binds everybody, including the government. 13, in our view, it is the right time to inform all the government bodies, their agencies, and the instrumentalities that unless they have reasonable and acceptable explanation for the delay and there was bona fide effort, there is no need to accept the usual explanation that the file was kept pending for several months, years, due to considerable degree of procedural red tape in the process. The government department are under a special obligation to ensure that they perform their duties with diligence and commitment. Condonation of delay is an exception and should not be used as an anticipated benefit for government department. The law shelters everyone under the same light and should not be shrill for the benefit of a few, considering the fact that there was no proper explanation offered by the department for the delay except monitoring of various dates. According to us, the department has miserably failed to give an acceptable and cogent reasons sufficient to condone such a huge delay. Accordingly, appeal are liable to be dismissed on the ground. That's the judgment.
Anything else?
This is the judgment, my lord. Now, this is 7.5 years gone by, and from the date of the incident, my lord, this is something, my lord, 10 years by now, my lord. And he has already suffered, my lord, because of a disciplinary proceeding. His service is no longer there, my lord. He has been removed. No.
Madam, one thing you were saying that you wanted to challenge the judgment.
We have already challenged in the appeal. Yes, we have filed one appeal along with the leave application. This
I know.
yes.
You want this condonation to be done because you want to make a challenge on the ground that the learned court below did not take into account relevant factors.
Yes.
Relevant factors like what? Like the evidence, you mean?
Yes. Because
And
trial
also
court did not take into
also that
account.
it took into account the minor inconsistencies made by
Little
the
bit of, yes, that only,
made
yes.
by the victim
Yes.
in her statement
Yes.
when compared to the evidence adduced
Yes.
by her.
Little
Correct?
bit of inconsistencies, my lord.
So the learned trial court took note of that and
Yes.
accordingly acquitted.
Yes.
That's all.
Lordship. And your lordship, the citation is of the division bench of the Supreme Court, mine one also like so division bench of the Supreme Court. And substantial justice, liberal approach, miscarriage of justice, if your lordship doesn't allow our application, because we don't have any interest state, except we want to protect the rights of the victim girl, your lordship.
But there has to be some finality to some issues. When, if you always say grave miscarriage of justice,
Yes, in
very
appeal, I will
good.
try to satisfy your lordship, in the main appeal, lordship, whether any miscarriage has been done.
Provided we allow your application.
Yes,
madam.
I leave it to your lordship's discretion.
Well, the cases has been cited by my friend, my lord, it is for 59 days delay.
I know.
No, no,
I know.
observations.
It was
quoted
with
for-
regard to
Well, it is.
2005, 2009, man, 2009 judgment. And it was with regard to just a few days, correct?
59 days
Yeah.
there, and my
Whatever
lord,
may
the
be
ground
popular.
is that there was a summer vacation, so consultant of the my lord, company was not available. And it is also a my lord, regulation matter that was allowed by the High Court. my lord.
Right. Heard Miss B. Bhuyan. Learned additional PP appearing for the state. and Mr. PJ Saike. Then it's wait, Mr. B. Buyan, assisted by Miss
M. Chakravarti.
M. Chakravarti. Also heard Mr. PJ Saike, senior advocate, appearing, assisted by Mr.
P borderline.
P. Borderline, appearing for the respondent. This is an application. Praying for condoning the delay of 2604 days in preferring an appeal against the what is that? In preferring an appeal against the judgment and order dated 29/9/2010. No. 29/9/2010. Passed by the Sessions Court, Morrigaon, in Sessions case number 112/09, bracket GR number 1056/2009, by which the respondent has been acquitted from the charge under section 376 bracket 1 IPC. The learned counsel for the applicant submits that unless the delay is submits that the request for preferring an appeal against the impugned judgment and order dated 29/9/2010 was received by the office of the public prosecutor from the office of the LR Commissioner Secretary to the government of Assam in the month of December 2017. As some pages of the judgment were missing, the office of the public prosecutor, Guwahati High Court, was intimated by the office of the LR Commissioner and Secretary to the government of Assam that the request for preferring an appeal against the judgment dated no, what have I said? Just read. As some pages of the judgment were missing, comma, the LR Commissioner Secretary of Government of Assam by letter dated 21/12/2017 informed the said fact to the public prosecutor, Guwahati High Court. Mr. What is this? I don't know. I can't understand what this sitting in there. Yes, what happened? So these pages were missing. Then what happened? I can't
We have written to
understand.
the LR, your lordship.
Ah,
We have written to the
So,
LR.
so LR told the prosecutor to get the to get the certified copy,
Yes.
correct?
Yes.
That was in December 2017. Then what else? After
And
that, what
thereafter, we
happened?
have filed, your lordship, after we received
Oh,
the
full stop.
certificate. copy.
Thereafter,
Well, it is not exactly, my lord.
that is what, this is not making sense.
This will clarify page 3, my lord, the Chubul can see, my lord. Page 3, first line.
Yes.
Request in this regard was not made by the public,
No,
by
no.
the public prosecutor who conducted the case for reason best known to him.
Request for what?
Well, the request had come from the public prosecutor of Morigaon to, my lord, the LR. Then LR sent it to, my lord, them. Then they found that some of the pages were missing. Then they have reported it to the, my lord, LR on 22/12/2017. And thereafter they have received the certified copy and preferred the
Because
appeal.
LR is the authority who
Now, my
instructs
lord,
us,
will
my lord.
find
Through him,
the
lordship
request.
direction comes,
Just
my
a
lord.
minute,
that
just a
order.
minute. That the request for preferring an appeal against the said judgment was received by the office of the public prosecutor. Which public prosecutor?
Of Morigaon district.
No, no.
Where does it say that?
My lord, this third line, my lord, at page 2, my lord.
Third line, page 2. Third line of which paragraph?
My lord, paragraph 3, my lord, page 2.
Yes.
Lordship may read, my lord, from fourth line.
No,
That
no,
the request
Mr.
for
Counsel, don't put words that are not there. When we see in the second line of para 3, it says public prosecutor. Now this public prosecutor, which public prosecutor?
Guwahati,
is
Assam.
Guwahati.
So lordship, since there was no explanation from them regarding
Just a-
delay,
just a-
again we have written, my lord.
Just a minute. So this office of the public prosecutor, nothing is there.
Presumably, my lord, they, my lord, because
You
they.
cannot presume
Lordship,
something that is not there. How can you presume?
Lordship. But the later part, my lord, from the fourth line, your lordship will find that the request for preferring an appeal against the said judgment dated 29/9/2010 from the present public prosecutor of Morigaon district had been received by the office of the LR commissioner and secretary to the Government of Assam only on 13/12/2017. Request in this regard was not made by the then public prosecutor who conducted the case for the reason
Just
best
a
known
minute,
to
just a
him.
minute. That's not the- Because of such a long delay, the applicants are also trying to confuse us with their language. It appears. Okay, whatever I said, just read from the beginning, that. As some pages of the judgment were missing. It says here, as some of the pages of the judgment was missing and as no explanation regarding the delay was forwarded to us. Now, who is us?
To ask your lordship to the office of the public prosecutor. It was filed by one of our public prosecutors. Additional. people.
Okay, by the office. As some of the pages of the judgment were missing and there's no explanation. As some of the pages of the judgment were missing, and as no explanation for the delay had been informed by the LR Commissioner Secretary to the Government of Assam, to the Office of the Public Prosecutor, Guwahati High Court, the said fact was brought to the notice of the LR Commissioner Secretary to the Government of Assam by letter dated 21/12/2017, issued by the Office of the Public Prosecutor, Guwahati High Court. Full stop. Thereafter, the LR Commissioner and Secretary to the Government of Assam wrote a letter dated 22/12/2017, to the Office of the Public Prosecutor, Guwahati High Court, stating that the request for preferring an appeal against the impugned judgment and order had been made by the public prosecutor, Morrigan District, and had been received by the office of the LR Commissioner and Secretary to the Government of Assam only on 13/12/2017. However, the request for filing an appeal against the impugned judgment and order had not been made by the public prosecutor who had conducted the case before the learned trial court, but by the public prosecutor who was in office in the year 2017. After receipt of the said letter dated 22/12/2017, the office of the public prosecutor, Guwahati High Court, started the process for filing an appeal and obtained a fresh certified copy of the judgment and impugned judgment and order only on 6/1/2018. The next para, the learned counsel for the learned additional PP submits that it was in view of the above facts that a delay of 2604 days had occurred in preferring the appeal. She praised that she submits that there was no deliberate delay or negligence on the part of the applicant in approaching this court after 7 years of delay. She also submits that unless the delay is condoned, there would be a grave miscarriage of justice. In as much as the learned trial court had not taken into account relevant factors and had considered minor inconsistencies made in the statement of the victim under section 164 CRPC vis-a-vis the evidence given at the trial. The learned additional PP thus submits that the delay should be condoned, and in support of our submission has relied upon the judgment of the apex court in the case of Oriental Aroma Chemical Industries Limited versus Gujarat Industrial Development Corporation and another, reported in 2010 14 SCC 419. Full stop.
Toshiba, judgment is IOC Limited by Subrata Bora. 2010
Oh,
14.
sorry, not that. It is that case. In the case of Indian Oil Corporation Limited and others versus Subrata Bora Chowlek and others, reported in 2010 14 SCC 419. Next para. Mr. P.J. Saikya, the learned senior counsel for the respondent, on the other hand, submits that the applicant has not given any day-to-day explanation for the delay. And as such, the delay of 7 years, and as such, the delay of more than 7 years should not be condoned. He further submits that in terms of the Assam Police Manual, in cases of acquittal, comma, where there has been a grave miscarriage of justice, comma, the district magistrate is to move the government for filing an appeal if a note has been sent to him by the superintendent of police stating that an appeal is necessary against the judgment and that the appeal was likely to be successful. Full stop. He submits that the application of the applicant clearly shows that no decision had been taken by the superintendent of police or the deputy commissioner to file an appeal, which is not in consonance with para 27 of the
Rule 27
Rule 27
of part 4 of the
of Part 4
of Assam
of
Police.
the Assam Police Manual.
It also prescribes the limitation period of 30 days, madam. 90 days perhaps.
He also submits that the appeal, if any, should have been filed within a period of less than 3 months
3 months.
from the date of the impugned judgment and order. Next para. The learned senior counsel for the respondent also submits that in terms of the judgment of the apex court in the case of Office of the Chief Postmaster General and others versus Living Media India Limited and another, reported in AIR 2012 SC 156. The apex court has held that condonation of delay is an exception and should not be used as an anticipated benefit for government departments. The law shelters everyone under the same light and should not be swirled, SWIRLED, for the benefit of a few. A separate period of limitation cannot be possessed by the government vis-a-vis the normal litigants, the ordinary litigants. He accordingly submits that the delay of 2604 days should not be condoned. We have heard the learned counsels for the parties. So basically, we'll pass the order. We'll pass the order later on, reasoned order today itself. It is basically rejected.
My contention as regards the police manual, may I submit your lordship, as regards the police manual, his reply to him, your lordship, that the officer of the, we are the advocates, with lawyers, we are responsible, my lord. In the sense, my lord, we are the officers of the court, we inform whatever the up-to-date proceedings to the department concerned.
Okay, just put one thing after that, just before we have heard the counsel, just say, Ms. B. Buyan, the learned additional PP submits that that as the office of the Public prosecutor, Guwahati High Court, is responsible for filing appeals along with the opinion of the public prosecutors in the districts,
Yes.
comma. It is not imperative that the views of the superintendent of police and the deputy commissioner should be taken for filing an appeal in every case.
Yes. Lordship, and we take consent from the LR department.
As so long as the consent and approval is given from the office of the LR and Commissioner Secretary to the Government of Assam Law Department,
Judicial, yes.
Law and Judicial
Yes.
Department.
My submission to counter this matter, the part 4 describes the role of the public prosecutor also, what he is to do, what he is not to do.
It will carry on this way.
That's right.
Because
What this
we are putting her submission because we are rejecting her application. All those LPs in view of the order passed in ISO and so, the application and the appeal are dismissed accordingly. Only the LP. Okay, the appeal is not registered. Only the LP is LP.
Criminal miss case, not the LP. First, condemnation has to be, delay has to be condoned, then leave, then the appeal comes.
No, but it has already been registered. The ones that are
183.
registered, those have to be dismissed.
Yes.
Yes, madam. That time, you need some more time to comply with that.
We missed the item. I have spoken to the SP Karimganj. What he said is that he had the accused had given two addresses, one from Guwahati and one from Calcutta. So he has written to the jurisdictional police officer of both the areas, and for sending him the documents. Yes, and that stage is pending. They have not sent the documents as of date, and he has to verify.
Okay.
This is the stage. He has written to both.
So how much time do you want?
1 month from today.
From what?
This is my prayer. 1 month from 17th of
Today?
17th of February. 17th of March it will end.
Okay, right. Heard Miss S. Jahan, the learned counsel appearing for the applicant, who submits that in terms of the judgment and order dated 30/11/2022, passed in criminal petition number 237/22, the state was to verify the documents and the records brought before this court with regard to the nationality of Sri Amit Bose within 1 month. Next para, the SP bracket B, Karimganj, Assam, thereafter wrote a letter dated 26/12/2022, praying that some more time should be asked for from this court for verifying the documents and record of Sri Amit Bose. You see, the first two paragraphs of the last order. Okay. Next para. Miss S. Jahan, additional PP, had been instructed to obtain instructions as to whether the matter had become infructuous and or whether the applicant needed some more time to verify the documents of Sri Amit Bose in terms of the judgment and order dated 30/11/22, passed in criminal petition number 237/22. Full stop. Next para. Ms. S. Jahan, additional PP, submits that she has received instructions to the effect that the SP has written to the 2 addresses of Sri Amit Bose, which is located in
One in Guwahati, one in
which is
Calcutta.
located in Guwahati and in Kolkata. We cannot say Calcutta anymore.
Oh, yes, Kolkata. Calcutta was better.
Yes, that depends. Yeah, I don't know. Depends upon the person. More people might
Yes.
like it. And
The locals would like to say that.
yes, Kolkata. She submits that the authorities in Guwahati and Kolkata, which authorities?
The police,
She submits that the
local
police
police.
the local police authorities in Guwahati and Kolkata have till date not provided the required documents to the SP Karimganj, SP B Karimganj till date. Accordingly, 1 month's time may be given with effect from today.
Today.
Full stop. Next para. The prayer of Miss N. Jahan, additional PP is allowed. The SPB Karimganj is given, is given 1 more month's time to comply with the, no, to verify the documents and records with regard to the nationality of Sri Amit Bose to be counted from today.
17th of February.
That is 17 to 2023. The I is disposed of accordingly.
Gotcha. Obliged.
Item number 5.
May please your response. I am for the appellant, my lord. It appears that the paper book is ready, but I have not received the paper book.
You have not received. So then.
We have received. Item 6.5.
Okay,
no?
right.
Yes.
Respondent number 3.
Huh?
I'm respondent number 3. I have received the paper book.
You have received paper.
Lordship.
Let us see, okay, is it written?
In the office note is written. Lordship.
Should be some note.
Full-muti Robi does.
Paper book has been furnished upon Miss B. Buyan.
Yes, yes. We have got it.
PP. Paper book has been received by respondent number 3.
Lordship. Respondent number 2 is also there, but I think he has not received.
This, who is for the respondent number 2?
His name is shown, but he is not present.
This is to certify that paper book is. It appears that not been given. Okay, right.
Lordship.
Mr.
R. Goswami.
R. Goswami, the learned counsel for the appellant, submits that paper book has not been furnished to him. Registry to furnish copy of the paper book to Mr. R. Goswami. This is the matter for hearing in usual course.
Provided the respondents are served.
What about R2 is
Service is complete.
Two respondents.
2 respondents. 2 and 3. We can appear for 2 also.
No.
You appear for 2 also?
No, only 3. Lordship. 2. Somebody has already filed his wakalat. Yes. No image shown.
Okay, okay. So it's a registry to furnish copy of the paper book to Mr. R. Goswami and to the counsel for the respondent number 2. This is the matter for hearing in usual course.
Highly obliged.
I'm sorry, my lord.
7, I think the Miss Bhuya has filed the objection here.
Yes.
So she will be back in few minutes. Lordship may take it up after some time.
She can start.
I start now.
Achha.
But here, the learned Sassan Judge convicted for 20 years under section 6 of POCSO. The affair just in shortly I am going affair page 1, very simple affair. Affair lost by the mother of the alleged victim. In paper book page 4, humble submission is that around 9:30 a.m. today, on 2/4/2021, my 12 years old daughter, Miss Swancho, went missing while I was going to Dergaon Narikal Guri Girls School. Her whereabouts could not be located even after making search in house of many friends and relatives. Therefore, inform you to about the matter for knowledge and necessity. That was the case, my lord. Now, my lord, the just some important point I want to show, my lord, that 164 statement, after the FIR, my lord, after some days she was recovered, and 164 pages in paper book 69, my lord. Page 69 in the paper book, my lord. Page 69 paper book, that is 164 statement of the alleged victim. My name is so-and-so. I am 13 years old. I am studying in class 7. I have been in love with so-and-so, present appellant, for the last 2 years. On 2/4/2021, he made a phone call to me and asked me to come to him without informing anyone, and said that if I do not do so, he would die. Accordingly, I went to the address in Guwahati provided by him, and I stayed there in a room separately for 4 or 5 days. Thereafter, we went to Nagaon, and I came to know from one of his related sister that he was married. Then I wanted to go back home, but he blackmailed me by telling that he would die, and he again took me to Guwahati. His father came there and took me to their house where I saw his wife and a daughter. The appellant did not allow me to leave his house, and he used to blackmail me by slitting his own hand. However, police rescued me. I had physical relation with him many times, and occasionally when I resist him, he engaged in physical relation with me forcefully. He blackmailed me by making false promise. Have to say this much only. Malat in 164, she is saying that she came to Guwahati.
Just 1 minute. Huh? We'll just-
Overwriting. Birth certificate overwriting. 2003 at 8 bonus. এইটাই হয় সেক্ষেত্রে মতো ইস্যুইং অথরিটিকে এক্সামিন করানো পুলিশের কইছে মই
ক্রোসত কিন্তু
ক্রোসত আনিছে আর একটা কথা আপনার
কিন্তু বার্থ সার্টিফিকেট খনক আৰু তুমি মেকাৰ অফ দি স্টেটমেন্ট ইজ নট ৰিকোয়াৰ্ড টু বি এক্সামিন্ড ন
না ইস্যুইং অথরিটি ফাইন যে ডিসপুট অ্যারাইজ suppose and then it was better to examine the issuing authority because the question was raised police also did not
at the time of hearing it to sum up at this bail crime officer to তেনেকুৱা লাগিছে prime minor লাগিছে
না ডক্টৰে কৈছে above 16 below 18 এটো লো বহুত ডিফারেন্স ডক্টৰে কৈছে এটো যে ডক্টৰ যদি above 16 below 18 কৰে তেতিয়াহ'লে এটা ডাউট আহি যায় যে বার্থ সার্টিফিকেট এটো 3 আছিল আৰু সলি টু 164 কলেজ মই নিজে গুৱাহাটীত গুছি আহিছিলো
না মোক কৈছে পলা যাব
আকৌ ডেপোজিশন যে দেইছে কোডত এটা কিছু মোক তারপরে বুকত কাকত কিডন্যাপ করে দিছে বিষয় কথা বলছে তে মোর কথা is to determine নহল অক্সিজেন সাবসিকুয়েন্ট গ্রাউন্ড সেকেন্ড 18 অফ কনভেল
যদি দিস ডকুমেন্টস আর নট বিলিভেবল তেতিয়াহলে আমি একো এনকোয়ারি কাৰণে পঠাব লাগিব because her age has to be determined bullet this is not believable
no then doctors report will be
no this is not legal birth certificate asa not it doctor likho jao so if this is not believable it high court can also inquire but better session just sends a report eto korbo lagbo but that will be in the time of hearing 8389
My lord. My lord, here the 164, the alleged victim stated that she came to Guwahati to meet the appellant. When appellant called her and both meet in the Guwahati, and after meeting Guwahati, they went to Barpeta and again come to Guwahati. Now, my lord, just some important, my lord, point I.
So he's married. You're married
Yes, ma'am.
with a child,
Yes, ma'am.
and you're having sex with a 13-year-old.
Well, in fact, she's Major, my lord.
Huh?
I want to say she's Major Mughal, my lord, and she knows very well that the appellant is a married person. Even then, she came, and my lord, the learned session judge, my lord, did not consider the overwriting of birth certificate, my lord. Birth certificate, my lord, to kindly examine here. It is, my lord.
So your basic case is that she's a major.
Yes, my lord. Major and inconsistency also, because in 164 she is saying I came to Guwahati, and in deposition she's changed her mind, now saying that he was going to school and the present petitioner kidnapped her from Dergaon.
No, it appears that she went willingly. It appears.
Yes, my lord.
Because it appears she went willingly.
Yes.
The question is whether she is a minor or not.
And doctor also, my lord. Doctor also.
No,
my lord,
just go straight to the point. Let us see the age.
My lord, kindly examine the birth certificate. I think record, my lord. It is overwriting, and in cross also the defense counsel raised that point, my lord. But it was not considered by the learned
where?
passengers. That birth certificate, my lord. I think it will be, my lord, 2003, but overwriting it is made, my lord, 2008. Then she become minor. Certified copy we have taken, my lord.
Then who will have the original birth certificate?
In fact, in the judgment, it is written that the original was produced.
Okay.
And that point was also raised at that point of time. And then the judge has meticulously scrutinized the birth certificate.
Let us see what is this finding.
That is at page 48. Oh, no. That is at internal page 11.
In the paper book?
No, judgment. No, that is not 11, internal page 11 of the judgment. Page 52.
52, paragraph 16, my lord.
Paragraph 16. Lordship will, initially they said that she also stated, mother also stated that she studied in class 7 and she was 13 years. Thereafter, Lordship will skip 10 lines from the top. Apart from the oral evidence, the prosecution has exhibited the original birth certificate of the victim, wherein her date of birth is recorded as 2/2/2008. Not only the defense pointed out, but also the court found an overwriting in respect of the year. However, on meticulous scrutiny of the birth certificate, it appears that the said certificate was issued on so and so. Therefore, the date of birth must be immediately prior to so and so. And that is 2/2/2008.
In last, my lord, here.
Second, on meticulous scrutiny of the document, through our experience, it appears that the year of birth is written as 8 and nothing else. The learned special public prosecutor has put the birth certificate over the torchlight, which clearly depicted the year of birth as 2008 and not 3. This experience is found relevant in the instant case. Thirdly, the prosecution has also exhibited the Aadhaar card, where the date of birth is 2008. Aadhaar issuing authority does not issue Aadhaar card unless all the data such as name and address, date of birth are found correct. There is nothing in the record to indicate that the said date of birth recorded in Aadhaar is not correct. Besides, from the medical examination, Exhibit 5, it appears that at the time of medical examination, the victim was above 16 and below 18. It is established principle of law that 2 years in both sides can be taken. Taking this guiding principle coupled with birth certificate and Aadhaar, it becomes crystal clear that she was 13, 14 years. So that aspect was gone into.
Well, if we believe and doubt that birth certificate, then the below 18 means 2 years flat in either side. So the court can presume that she is major. Because the IO also, my lord, stated before the court, though I found the overwriting, but I did not examine the issuing authority. And the learned court also did not examine the issuing authority. When dispute is found, because the vital document, since the birth certificate, my lord, relates to become whether major or minor. And that part is one doubt, man. And the medical report also, my lord, the doctor clearly said that above 16, below 18. So, my lord, the borderline. So, my lord, the birth certificate, maybe 2003 there. Because court, though, taken the view, but it is some different.
Doctors.
And doctors, my lord, PW 6, my lord. The doctors also clearly says.
PW 6.
PW 6.
Health
PW 6, my lord, the doctor, that is page 26, man. Page 26 and relevant portion is page 27. I did not conduct the radiology test. The age of the victim stated by me is based on the radiological report. The radiological report does not reflect the exact age. It may be vary also. Saying up to 18, even then doctor saying that it may be vary also.
We found her age 16 years and below 18
And
years. It's in the examination in chief.
In 313, my lord, the present petitioner said that, yes, she knows very well as the married person and voluntarily she came.
As far as 389 is concerned, this is prima facie. We will have to go through what prima facie evidence
Because,
is.
my lord, the
Here, prima facie, it shows that, yes, some exercise was gone into and the age was found out. During the hearing, if your lordship, he raises the issue again, lordship will again have to get the entire issue done by the district magistrate or the session judge.
And my lord, the IO, my lord, clearly stated, because when suppose she is minor, my lord, and subsequently, when she was recovered, immediately she went to the court and saying that, yes, I went to the Guwahati and I meet him in Guwahati. And in deposition in the court, my lord, suddenly changed because she is very talented, my lord. If you consider she is a minor, then they consider this way also. Can you examine the IO statement, my lord? That is, my lord, the page 29, PW 7. Before police also she did not state, my lord. Page 31, my lord, the victim so-and-so did not state before me. The IO saying, page 31 of the paper book, my lord, the cross of the IO saying that the victim so-and-so did not state before me that I was coming to my school for collecting books. The accused person who was near the Dorgaon Sariali bus stand suddenly arrived there and asked me to stop. I did not stop. He asked me to go with him. I refused. Then he told me that if I do not go with him, he would commit suicide by jumping under a vehicle. He told me that if he did so, the people around would understand that I caused his death. He blackmailed me. Out of such inducement, I went to him. He took me to Guwahati in the house of his elder sister. It was the statement before the court, but before police did not state it, my lord. Even before magistrate also it was not stated. And magistrate also not examined here. So, my lord, the case is, my lord, it is the case of, she is major, my lord. I think it is not the case of Poxo, my lord. So, if major, my lord, there is a concern, my lord. A girl from Dergaon come to Guwahati alone, my lord. What does mean, my lord? And now is 20 years, blood conviction is given the appellant, my lord.
He said that he thinks the thinking will not do here, whether she is minor or major. Exercise was gone into, she was found to be minor.
And every statement, my lord, denied by the IO, my lord, it was not, case was projected, my lord, subsequently. Otherwise, they cannot make their case, my lord. So all at the afterthought. my lord.
Class 7.
Class
Class
7.
7,
But-
class 7 girl.
7 girls, no document is produced, my lord. Verbal statement, because no teacher, no school certificate was produced.
No, when
How
there
we
was a
believe, my
birth
lord?
certificate, so school
The birth certificate
certificate was
is,
not.
if we believe even then, birth certificate is not similar with the doctor's report. Because doctor is saying above 16, below 18, and birth certificate also, my lord, overwriting also, my lord. So my humble submission, my lord, maybe consider it will be a case of acquittal, my lord. So bail may be granted at this stage, my lord, and matter may be hearing, my lord.
As far as bail is concerned, prima facie materials are there. And even if we see that there were some contradictions, but those do not go to the root of the case. Going
No,
to
root
school.
of the case is the birth
going-
certificate. The
No,
birth certificate from, the case is start from the birth certificate, because
No.
the in POXO case, my lord, the case is, the root of the case is the age, my lord.
Ah,
When age is not clearly determined, then
But-
subsequently will go, my lord.
He has raised two issues, minor as well as contradictions.
Yes, ma'am,
As far
both.
as minor, I'm saying that there is prima facie material. And as far as contradiction, it does not go to the root of
Which,
the
what
case.
contradiction?
Only that she, in her statement before the magistrate, she said that he called me up and then threatened me to go with him. And then I went with him. I did not say it to anyone because of threatening. In the statement before the trial court, she said, while I was going to the school,
Kidnapped.
I was threatened again. I was there at the bus stand and he took, and plus I'm saying, don't worry. In his statement before the magistrate, she said that she went to Guwahati herself. In her statement before the trial court, she said, he took me to Guwahati. So those are like 13-year-old girl, but the fact remains, when they stayed in Guwahati for 3-4 days, she was subjected to sexual intercourse. When she was brought to Nagaon, she came to know that he was married. Then she was again taken back to Guwahati. Then she was taken to Howli. Then she was finally recovered.
No,
So-
prima facie, it appears that there was some
Huh.
consent on her part to go here and there.
Yes,
You know,
might
because
be.
she was left alone in the house and all that.
She had said also love
Yes.
affairs and all. But she is a minor.
Only question is that age.
Age.
Yes, my lord. Because the Guwahati and Dirgao, so distance, my lord. How she said that, initially, my lord, when case was, my lord, registered at the time of investigation.
But what to do with this birth certificate that is here, that has been discussed by the trial court?
My lord, when any dispute arise, any documentary evidence, my lord, it was the duty of the court, my lord, that examine either issuing authority with come with the original record, my lord. But that part was not done. But the benefit given to them, my lord.
But that will not
And,
result in.
and on presumption is there. When doctor is saying, suppose doctor said that she is below 16 years or 14, 13, there is another presumption. But when doctor has gone up to 18, so it is the similar with the
But
my lord, 2000
doctor has said below 18.
below 18, my lord. So because if 2003 is written there, it was made 8, my lord. Very easy. 3 from 3 to make 8, my lord. Very easy, my lord. That part they have done. Why in a birth certificate is overwriting, my lord? Suppose it is a clean birth certificate. Why? In both places you have, it is under your custody. It is not my custody. How you have made it? So my humble submission, my lord. At present, my lord, maybe consider the bail, my lord. Because the hearing stage, my lord, immediately hearing will be. Then, my lord, finally it will be considered.
Had there been
Because
a
in the
case.
case of acquittal, my lord. Because in POXO case, my lord, very first, my lord, the court has determined the age, my lord. Only there is a prima facie maybe, therefore charge is framed. But when conviction also, my lord, given, even then it is under prima facie, then what will be, my lord?
No, what I'm saying is 389 application, Lordship has to
And-
go prima facie.
And
the
contradiction
materials.
also great, my lord, because serious contradiction.
It's this is prima facie. It appears that because the learned trial court has gone deep into it, at this stage, how can we say that the
Yes.
finding is wrong? It's on a question of fact. So what we can do is, in the meantime, we can direct that if the original can be brought, and you send it to the FSL.
That can be done, or Lordship can call for a report from the.
You send it to the FSL. in the meantime.
Hmm.
That will clear up the entire case.
Yes, yes.
And in the meantime, we dispose of this
Ah,
389.
yes.
We reject it.
Original birth certificate
we-
should be there here.
Inconsistency also very much there.
No, that will be at time of
Because-
hearing. That not at this stage. That will be amounting to reciting the entire case at this stage.
Just find out whether the original certificate is
Yeah,
there.
just see if it's there. If
Yes,
it's there,
yes,
then we can send it to the
Yes.
FSL.
Yes, yes, the original is here.
Then you send it to the FSL.
Yes, of course. This is exhibit number 1. No, there is overwriting. That's not not
No,
an
no.
issue. That has been gone into by the
Yes.
trial court. This is the
Yeah,
original.
no,
And my lord,
Let the FSL do it, yes.
in the office of the health department, my lord, where from the it was issued, my lord. It's also very much vital, my lord.
And there are overwriting in other things also, not only that year.
Because school certificate
Perhaps
was not
because of
examined.
water or something.
date of issue also there will be. But this is there. So this is the thing. So it seems quite correct. The trial court also seems quite correct. Because he could not have issued after this date.
Forensic report to how?
But
Because under section 94 juvenile, birth certificate to आपको
it is usually issued in after few years also it could have been issued. So we'll send it to the FSL.
And my lord, if possible, my lord, then issuing authority also may be examined, my lord.
No? Why?
This is
Because one copy is here, other record in the office, my lord. Because when they issue the birth certificate, one copy kept in the office, my lord. But it will be better, my lord.
We do not know if this will be.
Otherwise,
They don't.
if somehow they have collected, my lord, fraudulently, then FSL cannot say. Because only the official record will say, yes, on so date we have issued that certificate, and it will be very much clear because one copy already available in the office from in which office it was issued, madam. Otherwise, FSL will not say in which time it was issued.
We can ask them to try and get it from the office.
But under section 94 of the Juvenile Act, birth certificate issued by the municipality has to be seen. In order to
You see, the
judge.
problem is, will there be a second copy with the issuing authority or with the office?
That also I have.
I do not know.
I also
don't know.
Whether they keep it in the
Whether they keep it,
computers.
I doubt they keep a second copy.
Hmm.
But and that's otherwise they're going to keep how many billion?
Yes.
A billion certificates.
Not
We are
really.
1.3 billion in India. I don't think you're going to have 1.3 billion certificates.
If they have computerized, then there can
No,
be.
madam,
but-
may have, madam, because at the time of NRC, my lord, at the time of NRC, my lord, 15 years, 16 years, 20 years, my lord, back, when the birth certificate was issued, my lord, it was verified, my lord.
Verified is different thing. Keeping a copy is a different thing.
No, my lord, only I am praying, my lord. Suppose, my lord, in which office it was issued, I don't know. If, my lord, the police investigate or other way, the official person also examine. If they said that record is not available, that is another thing. But at present, my lord, FSL will what say? It will be better, I think, my lord, because whether it was issued 2003 or 2008, my lord.
No, issued on 2008.
2008. But date of birth is written there also, my lord, where from it was issued, my lord.
One thing, when you look state line.
This is 2008, written in English. Here it is written in Assamese. Here also 8.
We'll have the FSL, we'll see that let us have one thing at a time. Let us have the FSL report first. And then with regard to the records, but you see, they might not keep a copy of this, But it will be there in the register.
Perhaps,
madam.
yes.
They should be having a
Yes,
register.
madam. Now it is skipping, madam, the register. Otherwise,
And
madam-
but 2008 is not very, not ancient times.
yes, madam.
So you can
Registry-
check with the register.
Registry can be directed to call that part, that page of the register.
From who? From whom?
From date and birth.
No, you do it. Why should we ask the registry
Yes.
to do it? This is something that is your job,
Not-
not the registry's job.
Yes, I'll send the police, he'll get it one.
Okay,
at all.
you're right. Heard Mr. Nuddin, learned counsel for the applicant. Also heard Ms. S. Jahan, learned additional PP. The applicant's counsel prays for suspension of the sentence passed in special POCSO case number 36/2021 by the special judge Golaghat, and to allow the applicant to go on bail during the pendency of the criminal appeal. The applicant's counsel submits that the victim girl had willingly gone with the appellant to various places within Assam and had given her consent to the sexual relationship she had with the appellant, as she was a major at the relevant point of time. He submits that the birth certificate that was exhibited as Exhibit
One.
1,
One.
Exhibit 1 in the
M.
trial court.
M exhibit 1.
M Exhibit 1.
Material exhibit.
Oh, material.
M Exhibit 1.
No. Material exhibit 1 is the Aadhaar card. Material exhibit 2 is the birth certificate.
The other card is 2.
Oh, it's wrongly written perhaps in the
So
judgment.
M Exhibit 1. Oh.
It will be written on the top.
So what have we said? Last sentence. He submits that there is overwriting in the birth certificate of the victim girl, and the date of birth of the victim girl should have been 2/2/2003 and would not have been 2/2/2008. He submits that the overwriting in the said date of birth certificate would have to be verified. Would have to be verified. Oh no, would have to be verified as the victim girl was a major. First of all. Next para. Miss S. Jahan, the learned additional PP, submits that there was no infirmity in the date of birth certificate of the victim girl, and the said issue had also been gone into by the learned trial court in para
16.
Para 16 of the impugned judgment and order dated 21/12/2021. He submits that as the said issue was decided to the effect that the victim girl was 13 years, 13 years at the time of the alleged incident, there was no infirmity with convicting the applicant under Section 6 of the POCSO Act, 2012. So, it submits that the application should accordingly be rejected. Full stop. We have considered the submissions made by the counsels for the parties. The basic issue to be decided is with regard to the age of the victim girl at the time of the alleged incident, at the time of the incident. Full stop. At the time the incident occurred, the original copy of the victim's date of birth certificate has been shown to us, and we find that there is overwriting with regard to the date of birth of the victim and also the date of issue of the said certificate. We are of the view that the birth certificate should be examined by the Forensic Science Laboratory, Khanapara.
Not
Kailipara.
Khanapara, Kahilipara.
Kailipara.
Kahilipara?
Kailipara. And a report with regard to the actual date of birth recorded in the said certificate should be made. Pustak. In this regard, so who do we direct? The additional, the registry? Or what?
Registry, because LCRs will be
LCR,
with them.
What to do? With the original. In this regard, the registry of this court is directed to send the original birth certificate of the victim girl, which is exhibited as M exhibit number 1, to the FSL Kailipara for a report as to the actual date of birth recorded in the said certificate. And give the examination and report on the birth certificate should be made within a period of 1 month. 1 month from today. Next para. With regard to the present application for suspension of the sentence and grant of bail, we find that there is we find that as there has been a discussion on the question of date of birth certificate, question of the overwriting in the date of birth certificate of the victim girl, and now which shows that the age of the victim girl was, which prima facie shows that the age of the victim girl was 13 years at the time of the incident. We are not inclined to allow the application as on date. Accordingly, the application is rejected. The report made by the FSL should be reflected in the main appeal by the registry.
reading?
Yes,
Wait, please, Your Lordship. I'm sorry, Lordship, when this matter was called, I was in late, Lordship.
no problem.
Well, Lordship, I am appearing for item number 10 and 11, Lordship. 11. Yeah, Lordship, I is pending for suspension of sentence and grant of bail, Lordship.
This is
I have
what is this? You have been convicted under?
Under section 302 with aid of Lordship 149. So I have prepared one synopsis, just I am handing over to your Lordship. So here I am appearing in two criminal appeals. One appeal is criminal appeal number 98 of 2022. There are two appellants are there. Chandu Mia Loskor, alias Chandu. Number 2, Botol Mia, alias Botol. And in criminal appeal number 100 of 22, one appellant, that is Selimuddin Loskor. Here, Lordship, the incident occurred on 21/5/2006.
Who is appearing for in 12, serial number 12?
Counsel was there, Lordship.
12.
LR Majumdar.
Oh,
is
Mr.
there.
L.R. Majumdar was here.
Okay, anyway. This order will bind him anyway.
Probably not.
He is
No,
appearing for
Probably
other.
not, because Lordship, my case is that I have given the synopsis, your Lordship will find the learned trial court has relied on the evidence of PW 1, 4, 5, 6, and 7.
PW
1, 4, 5, 6, and 7.
Ah.
And in their implication, I have given in page number 2, your
No,
Lordship will
1,
find.
4, 5, 6, and 7 to what effect? To the effect that you are guilty.
No, to the effect that they have Lordship names few
Recognized.
persons, and accordingly the 5 persons are convicted. But if your Lordship sees their evidence, Lordship, just I'm giving the brief fact here before I go into the merit of the case. And as per FIR, Lordship, on the date of incident, 300 people clear out the house of the deceased, Lordship. So 300 people attack their house. This is the prosecution case basically, and they have identified 19 persons in the FIR.
Witnesses have identified 19 persons.
The informant has identified 19,
Informant has identified 19.
19 persons in the FIR.
Yes.
Charge sheet was submitted against 26 persons.
Yes.
And out of them, some were absconding and some were found juvenile. So ultimately, 12 persons faced trial. Seven persons acquitted, 5 persons convicted.
7 persons convicted.
Acquitted.
Acquitted.
Lordship. 5 persons convicted. And appellant in criminal appeal 98 of 2022, Lordship, that Chandumia Loskor and Botolmia.
Yes.
They were not accused initially, Lordship. They were arraigned as accused in 319, Lordship.
319 meaning?
During trial, under section 319 CRPC, they were during trial, their name came up and therefore they were arraigned as accused. And one of the accused who was on similar footing, that Jalal Ahmed Majumdar, who was on similar footing with Chandu Mia Loskor and Botol Mia, he preferred a criminal revision against that order before this honorable court. And this honorable court, finding in some irregularities, has passed the order, and he is now at large, Lordship.
He is now what?
He is not an accused now.
Who is that person?
Jalal Ahmed Majumdar. That I have noted in my synopsis, Lordship. Page 1.
Yes.
So this is the case, Lordship. And I am on similar footing with Jalal Ahmed Mozumdar, whose criminal petition was allowed, Lordship, in the before by this honorable court. And on the other hand, your Lordship will find, just your Lordship may kindly take the second page of my synopsis, Lordship. That will make clear, Lordship. First, PW1, Madan Kumar Baban, he regarding that assault part I am reading, Lordship, page 2, second page, Lordship. Korimuddin assaulted Dhan Singh Burman. So just here I'm pausing for a moment, Lordship. Korimuddin, he is not an accused. From day one, he is not accused till date. He is the main assailant. Your Lordship will find in the subsequent statement of PWs also. Korimuddin assaulted Dhan Singh Burman with a lathi, and Abidur gave a bollam blow to Dhan Singh Burman. So Abidur is item number 12, which is I am not representing, Lordship. The other accused,
who is Abidur is item 12.
Item 12. The other accused persons also assaulted Dhan Singh with lathi, knife, etc. So here I am not Lordship. My submission would be, Lordship, that statement will not implicate me, because the learned trial court has already disbelieved him and acquitted the other seven persons, Lordship, who are also within this statement, Lordship, that the other accused persons also assaulted Dhan Singh with lathi. So if it is accepted, then 7 persons would not have been acquitted, Lordship. So I am not coming in PW1. Now PW4, he said when Dhan Singh Burman came out, he was assaulted by accused Karim Mia. Again Karim, Lordship, but he is not an accused. On his head, which is, Lordship, corroborated by medical evidence. Then accused Abidur assaulted him with bollam. So again Abidur. Others also assaulted him by dao, lathi, etc. So from others, Lordship, already 7 persons acquitted. PW5, Sarvani Burman says, accused Abidur called my father to come out, and while my father came out, accused Karim assaulted my father on his head with lathi. Thereafter, accused Abidur and Haidar. Abidur is 12, Haidar is not an accused. Assaulted my father with bollam. So main accused are not there.
What is this bollam?
It is
It's
also
a wooden
agriculture.
batten, no? It's an wooden batten. Kind of.
Agriculture.
Used for what?
For agricultural purpose, it is used.
What do you do with it?
It is to broke the piece of hard earth, Lordship.
Okay.
In the,
So you all didn't know about it.
I didn't know why it is used, but
So it's a wooden what, stick or something. I mean, the wooden
like-
it's a
club.
big,
hammer. It's like hammer.
rounded thing.
Club.
Batten hobo.
It's a club,
like hammer, it is like
hammer.
like hammer. Wooden hammer.
It's a rounded big thing.
Hammer type of.
One end I think is little thinner than the other end. Other end is bigger.
Okay, it's a stick with a rounded end at one end.
Kind of.
With a round end. Okay, then
PW5 also says nothing about my appellant's, Lordship. And now PW6, Motindra Burman, when Dhan Singh Burman came out to courtyard, he was assaulted by Karim, again Karim, Lordship. Thereafter, accused Abidur assaulted with bollam. Accused persons Haidar and Botol also assaulted Dhan Singh Burman. So first time PW6 says only about Botol. One of the appellant in criminal 98 of 2022. Therefore, he was arraigned as accused in the case, Lordship, because of this statement. Now, PW7, Kalpana Burman says, they, in bracket, it was used as accused persons attacked the house of Dhan Singh Burman and killed Dhan Singh Burman. So, no specific statement by PW7. And regarding that one statement of PW6 regarding Botol, just I am placing one judgment of Honorable Apex Court, Lordship. Here it is said when large number of accused persons are there, it is, Lordship, better to rely on rely on 2 or more witnesses who state consistently about the accused persons, Lordship.
Exactly.
Because here 300 persons were there. So whether some consistency is there or not. That is why. Regarding Korim, Abidur, Hadar, that is consistent. But regarding Botol, only one witness said that is. Therefore, the Lordship may kindly say paragraph 31 of the judgment.
Regarding bottle, where? Who says it?
PW6 said. Lordship.
PW6.
But others they did not say about Botol.
Bottle, okay,
Yes.
bottle. So, Chandu Mia's name is there or not?
His name is, regarding assault, his name is not there.
His name is not here.
Not here.
Then
Regarding assault part.
what about Salemuddin Lashkar?
Regarding assault part, his name is also not there.
And they have been convicted under 302.
With aid of 149.
149.
With aid of. So 149, whether here will come or not, whether these evidence witnesses are reliable or not, we stated only once, Lordship. That is a matter of argument. But here, your Lordship will kindly come to paragraph 31 of this judgment, Lordship.
149 or 319?
149.
149.
Unlawful assembly, Lordship.
Okay, IPC you talk about.
IPC, Lordship.
Okay.
Vinay Kumar Singh.
Yes, 149.
Yes, 140, unlawful assembly. Muscle.
Yes, so the judgment is
Paragraph 31, Lordship. We have noticed that
just a minute.
it is reported in SCC 1997, volume 1, page 283, Lord.
Yes.
Paragraph 31, Lordship. We have noticed that Mitunjaya A23 and Parmanand Sharma A20 and Madan Mohan Sharma, son of Ambika A24, were identified by more than 2 eyewitnesses as participants in the occurrence. Out of those witnesses, the testimony of PW10 and PW32 was accepted by both courts. As for the remaining appellants, both courts have accepted the testimony of at least 3 witnesses, each for referring to each appellant. There is no rule of evidence that no conviction can be based unless a certain minimum number of witnesses have identified a particular accused as member of the unlawful assembly. It is axiomatic that evidence is not to be counted but only weighted. And it is not that quantity of evidence but the quality that matters. Even the testimony of one single witness is wholly reliable, is sufficient to establish the identification of an accused as member of an unlawful assembly. All the same, when the size of the unlawful assembly is quite large, as in this case, and many persons would have witnessed the incident, it would be a prudent exercise to exercise on at least 2 reliable witnesses to vouchsafe the identification of an accused as participant in the rioting. In Masalti versus State of Uttar Pradesh, reported in Sanso, a bench of 4 judges of this court has adopted such a formula. It is useful to extract it here, where a criminal court has to deal with evidence pertaining to the commission of an offense involving a large number of offenders and a large number of victims. It is useful to adopt the test that the conviction could be sustained only if it is supported by 2 or 3 or more witnesses who give a consistent account of the incident. So here the case was of 57 persons were involved in the present judgment. And in my case, Lordship, 300 people were there. It is admitted fact, Lordship, by prosecution. 200 to 300 people.
So
only one
it
witness
just says
has,
that it would be a prudent exercise.
yes, Lordship.
It says that, but it also says that if the testimony of one single witness
Yes,
is wholly reliable, it is sufficient.
sufficient. But in Lordship, it is in next line, your Lordship will find when there are large number of persons, it is prudent.
Prudent means out of caution.
Yes, because Lordship, what I am placing your Lordship is that initially Botol was not named in the FIR nor in the charge sheet. Only while deposing before the court, his name came up, Lordship.
How does
So
that matter?
if a name came up for first time, then
So
also I am getting benefit.
Even if
Lordship.
if you're not named in the FIR, subsequently your name crops up, everything is not known straight away during the FIR. FIR is only the start of a registration of a case.
Yeah, but during investigation, my name ought to have come up also, but that has not there. So first time while deposing for court, my name came up.
That is by 319.
So your name came up only during trial.
During trial. So first time when my name is stated by the witness, Lordship. That
For all
regarding
three of
bottle.
you all, for all three of you all.
No, only bottle. Others implication are not there. Other two persons, Chandu and Selim, regarding them, it is not.
Chandu Miao, this one. 319 I said.
Oh, Chandu Miao 319 is.
So bottle and Chandu Miao.
Bottle and Chandu.
Chandu Miao appearing to. So bottle
And
and Chandu.
my main case is that, Lordship, from the evidence here, Lordship has seen that main assault was given by Karim Haidar. They are not the
Main assault. Main assault means what?
The fatal blow.
He hit the hardest.
The fatal blow which is given in the
Fatal
head.
blow was given by. How, with what?
With Ballong, Lordship.
That cannot be
Lathi.
said. Who
How
had
do
given
you-
the fatal blow is not clear.
No,
They are the
that is a-
starters. They had started perhaps the assault.
Anyway, anything else to say? Anything else?
That the other persons who are on similar.
So
field, they were
according to
acquitted,
you,
Lordship.
if we have got it right,
Yes.
Botol's name is there in the evidence. That's
Only
one of the
one
persons.
witness
was-
said, one witness said. for
The
first
names of the other two persons are not there in
Not
the
there.
evidence.
participant. And regarding Botol also, Lordship. he-
But they were there as what? As to see the show. They were in the crowd. huh?
Probably.
They are not
Lordship.
the spectators. They have
Because
participated.
participation is not clear. And regarding Botol also, Lordship, one of the accused who was also arraigned as accused Jalaluddin under section 319. His case was allowed by the Honorable Court in criminal petition, Lordship. He is on similar footing with that. Because of poverty, he could not come and he had to face the trial, Lordship.
Jalaluddin's name is not here.
No, he was arraigned as accused under section 319. Against that order, he challenging that order, he came up before this Honorable Court. I without challenging that order, I faced the trial, Lordship. This is the difference. He challenged that order.
Challenge the framing of charge order.
No, challenge the order whereby three persons were summoned as accused, Lordship. So his application was allowed in his regard. We faced trial and now we are in custody, Lordship. Otherwise, we would have been also out if we were probably, Lordship. I'm not saying that, but on a similar footing, Lordship. We are. So considering that aspect, Lordship, we may be allowed to go on there. During trial also since 2006, they were on bail. They never misused their liberty, Lordship.
Okay, who is appearing for this Abidur Rahman?
LR Mozumdar was here, Lordship.
Okay, yes, madam.
As far as Chandu Miao and Bottle in this appeal is concerned, there are in fact 8 witnesses who have recognized him.
Okay.
PW1, there is no quarrel with the proposition of this Masaltis case. In case of mob fighting, it is better if 2 or more witnesses recognizes the offenders, and then it becomes more believable. No quarrel. In fact, here more than 2 has recognized it. One PW1, he had accompanied the deceased. Actually, what had happened, there was a meeting initially, and there were 200 to 300 people had gathered in a school. And then something happened in the meeting, and then a mob shouted Burman Maro, and then they rushed to the place of the deceased. Deceased and his family members fled from their own house. And then after that, they rushed, and then one of the persons said that call the deceased. We will have a talk or something. Then deceased came out. His family was there, hiding in some other place, and the deceased came out. And then they assaulted him. Along with the deceased, PW1 also came out along with the deceased. They both came to the house of the deceased, where the entire mob had gone and attacked. There, PW1 had recognized both these persons to have assaulted. It is there in the evidence. PW1, who had gone along with the deceased. The son of the deceased, PW2, they had stated the same facts. All of them, one of them called his father. One of the assailant called his father. And when his father came out, he took him to his own house and assaulted him there. And that
Who
PW,
took him to his own house?
the person who had called the father,
Who was the person who called? the
one
father?
of the assailant, one in the entire group. So when the father came out, the entire group took him to the father's place. And then he was assaulted there. And they have recognized, they were there. It was in the broad daylight. 4:30 p.m. It was in the month of May. It was all light up. And then PW1 had seen, PW2 he had also recognized, he recognized applicant number 2. PW2 has recognized applicant number 2, Botol, as a part of the unlawful assembly who had attacked his father. PW3 is there, the wife of the deceased. She had also stated the same facts, and she recognized both the applicants to have assaulted the husband. She has recognized Botol and Chandumia.
Who has recognized?
PW3, the wife of the deceased.
Oh, he's not mentioned that.
She has recognized both the accused to have assaulted her husband.
Just a minute.
PW3 has said.
Lordship, may I kindly see paragraph 32 of the judgment, that is page 34 of my appeal memo. In the judgment itself, whatever I have given to your lordship is mentioned here.
So from the examination, from the deposition, lordship, I can show it.
Yes.
PW3. Chandu and Botol, she had said in clear terms.
No.
Are the accused Botol, Chandu, Haider assaulted my husband?
Chandu also.
Chandu,
is there.
yes. Yeah.
And what about this Salem Uddin Laskar?
Salemuddin, no, Salemuddin, no, different one.
In the other case?
Yes, yes. In fact, I had called out who had said what in respect of Salemuddin also.
So PW3 has named Botol and
Chandu.
Chandumia.
PW1 also.
PW1.
PW1 is the person who accompanied the deceased to his house.
Regarding that, lordship, that clause part has to be seen. Therefore, I have said, lordship, in the judgment, what I have placed before lordship from the judgment. Just one line from the clause of the PW3 I am reading out. It is not a fact that before IO, I did not disclose the name of the accused Chandu and Botol as assailant. So that may be verified. Let her verify. It is not stated in 161. Therefore, court has disbelieved it. And therefore, clear finding is there regarding who assaulted whom at paragraph 32 of the impugned judgment. Lordship, may I see? I have whatever I have submitted from the judgment itself, lordship. Not from my own, lordship. It is on record.
She's saying it from the evidence.
Yes, but in 160, in cross examination, evidence has to be read in the chief and cross as well. In cross, lordship, here it was brought to her notice that she has not deposed before the IO regarding Botol and Chandu as assailant.
That
is
all those contradiction, whether it was proved, not proved, we will go through it during the time of hearing.
So
As
therefore,
far as
lordship, I am saying
389.
therefore, I am saying the trial court has considered all this aspect, and thereafter paragraph 30. Lordship, for a moment, lordship, see the impugned judgment, paragraph 32. There itself the name, it is mentioned who assaulted whom, lordship. From that I have quoted. Paragraph 32 of the judgment, where appreciation of evidence. Is there is after considering 161 and court deposition, lordship, this findings was given. Because in my humble understanding, cross cannot be isolated here from chief. Both have to be read together.
Anyway, we'll give you a chance. Let her continue. We are
Lordship,
butting
yes.
in the middle of her.
Yes,
submission.
that is
You
what.
just wait.
In fact, that sometimes so happens that they state to the police, but it's written like this. So we will have to check the 161 statement. That we will do during the time of hearing. But as far as the prima facie materials are concerned, PW1 is there in that case. PW1, lordship will see, he had named accused Abidu, Karimuddin, Ainul, Botol, Chandu, who were persons known to me and have assaulted persons known to me. Karimuddin assaulted Dhamjit Burman with a lathi, and Abidur gave a ballam blow. These are the two persons who started, but these were the members of the unlawful assembly.
What about Salem Uddin Lashkar?
Salemuddin Laskar, Lordship, Napali objection. Salemuddin Laskar, I filed my objection and I have called out what is there. I'll just take the
Yes,
IA once. Just an IA one. Because taking out the names from each and every witnesses becomes a very difficult task. Salemuddin, no? Salemuddin, I've got it, Lordship. Salemuddin, PW2. Salemuddin is the only applicant, yes. PW2, the son of the deceased, he has recognized Salemuddin. He also stated that he recognized the applicant amongst the assailants. PW2, the son of the deceased. Lordship, I'll just read it from here. My father fell in the ground. Accused Bottle Ainul Salem also assaulted my father by gun, lanja, dagger, lathi, etc. PW2 said about Salem. Then PW3, but she is not, no, the 3 did not say anything. Three said she could recognize all the accused persons in that heated atmosphere, but clear terms she did not name anyone. PW2 is the only person who had named Salem clearly. Three is, as far as Salem is concerned, 2 is the only person who has named him specifically. Chandu Bottle, PW number 1 and PW number 3 had stated. PW, in fact, Bottle is named by so many. Bottle is named by 1. Bottle is named by 1.
3.
3, yes, 3. Then 4, no. Then the 5, applicant number 2 had assaulted the deceased. 5 had said the daughter of the deceased. 7 is also an eyewitness. He recognized the applicant number 2, Bottle, who led the mob who attacked the deceased and family and destroyed properties. So these are the witnesses who had stated about the applicants.
So Chandu Mia has been identified by 1 and 3.
1 and 3. Bottle is identified by 1, 3, 5 and 7. And Salemuddin by 2. During hearing, I'll make a chart and I'll give your lordship. It's difficult in a mob fight.
Yes, anything else?
Lordship, what my submission to Lordship is that the main accused, that Karimuddin, they have not brought him as accused. Thereafter, Lordship, Jalaluddin, who is on similar footing with Chandu and Botol Mia, Lordship, against them, Lordship, they have not done anything. So on the ground of parity also, Lordship, I am entitled to bail. This is my humble submission before Lordship. And whatever my learned friend has said, that already is disputed in the cross-examination that they have deposited for first time in the court. And therefore, considering this also in the paragraph 32, the learned trial court has observed that who has assaulted. So from that also it appears that main assailants were that Karimuddin, Abidur, and Haidar. No. Even against Karimuddin, charge sheet is also not filed.
Something must have happened, died or something. I'll have to again check that.
But Karimuddin, how is it relevant?
Because
Not
Lordship
relevant.
Korimuddin assaulted Dhan Singh Burman with
That
lathi. So first-
he will take care of his own case. Why are you so bothered
No,
about
no, he
his?
is not an accused.
No, Abdul Karim, no. His case was filed. He's an absconder.
Korimuddin. It is Korimuddin.
Karimuddin, Abdul Karim, again.
No, no.
And the other one is what?
Other one is Abidur is before this court and Haidar.
Hyder Ali is dead. But there is one Abdul Karim whose case was
He
filed.
is different person. And Jalaluddin's case, he was similar with our case. So we have been arrested accused under section 319. Same order he challenged before this honorable court and he got lordship acquitted.
You should have challenged now by
Because of poverty lordship, now I am before your lordship.
what to do.
On
Now in the
meriting ground,
meantime,
lordship, because if there is anything, during hearing, they can submit it, lordship.
in the
And
meantime,
from since
in the meantime, the witnesses have identified you. What to do?
No, they have identified prior to my implication, lordship. Therefore, I was called to attend the trial, lordship. On similar footing with Jalaluddin. And even PW2, what my learned friend has said, just I am reading one line, lordship, from his evidence. A large mob of 150 and 200% gathered our village, being led by Jalaluddin. So he was the main person. He was now out.
So those are their
Because
luck
there
or
has to be
their
parity,
merit of the
lordship,
case.
because 300, 200. to
Those are
300.
water that has already gone under the bridge.
For some reason or the
But
other.
that at this stage, lordship, during hearing of bail, lordship, probably I will get some benefit because whatever they are in the material which I have already placed, that if case of Jalaluddin can be, lordship, was at the 482 application, lordship, definitely these applicants who are on same footing, they probably will get acquitted, lordship. So, who the person
Where is that?
that it is mentioned in the judgment itself, your lordship will find. Paragraph
Cannot say in the same footing. Marriage was
Let's
seen.
see what he said.
Paragraph 8 of the impugned judgment, lordship. Paragraph 8, page 18 of my appeal memo.
Why was it set aside? We don't know.
Hmm.
Yeah, where is the order also you have not produced?
That was produced before the trial court, lordship. Therefore, case
Maybe,
number is
but
there.
then we have
everything is
got to
there.
see whether your case is similar to that.
So that your lordship will see at the time of hearing. But at this stage, lordship, I am praying for bail because they were on bail since long, lordship, and they have never misused. There is nothing on record to show that I have ever misused the liberty of bail, lordship. And 300 persons were there, lordship. It is admitted by them, lordship. 200 to 300 people.
Unfortunately, you are one of the few who are identified. You should have worn
No, but
mask with blacks.
No, identified regarding lordship only presence. What my submission to your lordship is that. And as I have given the chart, lordship, the other witnesses which my learned friend has said, they have not deposed before the investigating officer, the initial stage. Subsequently, when trial was going on, they have, oh, he was there. That cannot be, lordship, in my humble understanding, lordship.
But
Because
then-
Honorable Apex Court has said in judgment that the witness who deposed first time in the court, it creates some doubt. Because she could have identified
That
earlier
has not
also.
said that. Nowhere has it said create some doubt.
No, that judgment
That
is
you
there.
are putting
lordship.
words into the
No,
judgment.
that judgment is there. I can produce before your lordship.
No point.
Tomorrow, Monday or
No.
I can produce that judgment. It is there.
Heard Mr. R.A. Chaudhary, learned
Yeah,
counsel.
yeah.
Huh?
Yeah, Ahmed.
A.R. Chaudhary.
Yeah.
Yeah, Ahmed, learned counsel for the applicants. We will begin to common order, I think.
But then LR Majumdar's matter has to
We
be
have
left
to,
out.
that we have to leave out. This item, 10 and 11. Huh? Mr. Ahmed, learned counsel for the applicants. In in IA criminal 239/2022 and IA criminal 244/2020. So I've also heard Ms. S. Jahan, additional PP. The above two applications are have been made for suspending the sentence imposed upon the applicants in view of their conviction under section 302 IPC pursuant to the judgment dated 23/3/2022 passed by the court of the additional session judge, FTC at Kachar, Silchar in sessions case number 105/211. At 302 IPC read with 148.
147, 149.
No.
Huh?
The what?
Under 148, 448, 302.
302 read with
149.
149 IPC.
Trespass. 448.
The applicant's counsel submits that the applicant's names were not mentioned in the FIR nor in the charge sheet. However, due to the evidence of prosecution witnesses who had named the applicants, the applicants along with one Jalal Ahmad Mazumdar, were arraigned as accused persons before the trial court under section 319 CRPC. While the applicants herein participated in the trial proceedings, MD Jalal Ahmad Mazumdar filed criminal petition number 160/2014, challenging the order of arraignment. First up, this court, by order dated 4/7/2014, disposed of criminal petition 160 of 2014 by setting aside the order of arraignment of the accused dated 28/8/2014. Next para. The applicant's counsel submits that the applicants should also be given no, would also have been given the same order if they had approached this court by challenging the order arraigning them as accused. Arraigning them as accused. However, due to poverty, the applicants could not approach this court. Next para, the applicant's counsel submits that there is no mention of the applicants in the evidence of the accused with respect to assaulting the deceased, except for the applicant Batal Mia alias Botol, BOTOL. He submits that as only as only one witness, that is PW number 6, has identified, allegedly identified Batal Mia alias Botol as one of the persons who assaulted the deceased, amongst a large crowd of 300 persons.
200 to 300.
200 to 300 persons, the learned trial court could not have made any finding convicting the said applicant Batal Mia alias Botol in terms of the judgment of the apex court in Binay Kumar Singh and others versus State of Bihar, reported in 1997, 1 SCC 283. He accordingly submits that the sentence imposed upon the applicants should be suspended and they should be released on bail. Next para. Ms. S. Jahan, additional PP, on the other hand, submits that the evidence of PW 1 and 3 clearly identifies the applicants Chandu Mia Laskar alias Chandu and Batal Mia alias Botal as the persons who had assaulted the deceased. Further, prosecution PW number 5 and 7 had also identified Botal as one of the assaulters and
PW2.
Huh?
Oh, Selimuddin is PW2.
Selimuddin Laskar is one of the.
PW2 was original reference case, but that is in different appearance.
Next, she also submits that PW number 2 had identified Salim Uddin Laskar, alias Salim Uddin Laskar, the applicant in I number 244/2022 as one of the assaulters of the deceased. She thus submits that as the issue of whether there was a prima facie case was required to be gone into with regard to an application under section 389 CRPC, the fact of the applicants being a part of the
As non-lawful assembly.
huh?
Unlawful assembly.
A part of the unlawful assembly, the present application should be dismissed. That's all. Anything else?
Not.
Okay, then we'll pass the order. Huh? As completed during lunchtime. You come on. So basically, we are dismissing it.
And registry may be directed to prepare the paperwork.
Yes, in the main case. In the main case, we just write so appears as LCR has arrived, registry to prepare the paper book. Then in item number 12, you write as no one appears on behalf of the appellant/applicant, and list the matter in the next page.
To of the Indian Penal Code.
302.
Yes, Your Lordship, and appellant has been convicted for life imprisonment. The informant is the father of the deceased, Jitendra Rajak, and in this case, in total, 13 number of witnesses has been examined.
My friend has said it is going to take some time.
It will take time, Lordship, because there are total number 13
Can you take it up
witnesses.
in the coming week then?
We're ready for it.
Yes,
We've
we
got
are.
time, I
I'm
think.
also ready.
Then no issue, Lordship. From Monday, there is another bench.
So, every day there will be a bench.
Lordship.
I mean, it's a different bench. I'm not.
Different bench.
No, same bench.
Same bench, but
Probably Justice
Okay.
Saikia will not be
Justice Saikia
sitting.
will not be available.
Okay.
on
So it
Monday.
said like, if it is part hard, then it will be like,
Okay. So you will take how much time?
So, Lordship, almost 1 hour, more than 1 hour, Lordship, because I have to read all the witnesses thereafter.
Any eyewitnesses?
yes,
Yes, Lordship, eyewitnesses are there.
How many?
Four.
Four
Then
eyewitnesses.
no. Then
But I will try to satisfy Lordship that they are not the
you
eyewitnesses.
can do it.
Lordship. I will start, Lordship.
Then
Lordship will find the FIR at page number 4 of the
page
paper
4.
book, page 4. It has been lodged by Naresh Rajak, the father of the deceased, who has been examined as PW1 in the case.
FIR dated 14.
FIR at 14/1/2013.
Yes.
The incident
13/1.
of 13/1/2000 at about 10:30 p.m.
Yes.
May I read the FIR? Lordship?
Yes.
I have the honor to inform you that yesterday at night about 10:30 p.m. while my son Jitendra Rajak was coming from shop by purchasing some household goods with his friends, see Raju Mahato. Raju Mahato, he is not examined. Thereafter, Munna Rajak, he has been examined as PW3, and Sumit Rajak, he has been examined as PW2 in the case. Suddenly, one Aziz Ali, along with his 2 unknown associates, attacks on my son with a
Just
deadly
a
weapon.
minute. Raju Mato is PW,
Raju Mahato not examined.
not examined.
Not
Muna
examined.
Rajak,
Munna Rajan PW3 and Sumit Rajak PW2.
But Raju Mato was made a witness also.
Lordship.
Was
that
he
I
made a
have to-
witness?
Lordship, in the search sheet, I have to look into Lordship.
Rajiv Mahato is.
Search sheet.
Raju Mato.
Raju
No,
Mato.
one Rajiv
Search sheet
Mahato.
is at page 99. I have to see that.
The one Rajiv Mato is there.
Yes.
Yes,
Okay.
but Raju Mahato is
Maybe
not
same
there.
person.
That can be.
Rajiv and Raju,
Huh.
sometimes by pet name.
Raju and Rajiv cannot be same.
Sometimes well, pet names are sometimes shorter.
Lordship, in the list of witnesses, his name is not there because in the list of witnesses there is
Okay,
Rajiv
anyway,
Mahato.
okay, then
Rajiv Mahato, PW6.
Raju Mahato has said.
To Raju, no?
Raju is not there.
in the FIR, his name is Raju.
Yes, but in the cited in the witnesses list in the search sheet, his name
No,
is
no,
not
it to
there.
Rajiv Mahato, eyewitness PW6.
Hi. But in the FIR, it is
Okay,
Raju
so
Mahato.
that could be either it could be a wrong spelling
Yes.
That can't be said.
or it could be a different person.
Different person also.
We don't, let's see.
One Aziz Ali, along with two unknown associates, attacked on my son with deadly weapon, that is iron rod and dagger.
No, same person, PW6. Father's name is Chandika Mahato. Same.
Okay, same.
And dagger, big knife, and put it 3 times in his belly and his stomach, and due to which he sustained grievous injuries. He also threatened the other friends that if they do anything for saving him, he will kill all his family members. That's so and so. I, with the help of local people, admitted my son in the Assam Medical College Hospital, where he is admitted in ICU and his condition is very critical. That I also informed the police and explained all the facts before him. But due to busy in the treatment of my son in the hospital, I could not lodge the Azahar immediately. That after the incident, the said Aziz Ali came again near my residence and threatened my family members, asked that he is the informant of the police. And if any complaint is lodged against him, he will kill all my family members. The above named person is a habitual criminal of the locality and several cases is pending against him. Lordship, that much. Thereafter, appearance so and so cause harm with family members at the moment. Accordingly, on charges were also framed.
302.
302. And thereafter,
Against the appellant only.
yes, but in the FIR, it has been stated that there are some more unknown persons.
You're there, it's enough,
Yes.
you're caught.
Yes, yes,
It is like this Englishman who was
Yes.
supposed to be hanged.
yes.
So the hangman asked him, what are your last words? So he said, oh, but I've only got one head to give to my country. So the hangman says, doesn't matter, every little head counts. So you're the main guy, at least one.
Yes, yes. that I also. Lordship, may I read the evidence of PW1 at page number 8? The informant of the case, father of the deceased, Naresh Rajak.
Page?
Page 8 of the paper book. Naresh Rajak. I know the accused person. I am the informant of this case. This is Jitendra Rajak was my son. On 15/1/2013, my son died in Assam Medical College and Hospital, Dibrugarh. I have a laundry shop. After 2 days.
The incident occurred on 14/1.
13. After 2 days, he died.
Okay.
On 15.
Incident occurred
on 13/1/2013.
2013
Yes.
at 10:30 p.m.
10:30 p.m.
10:30 p.m.
And he expired on 15/1/2013.
What time?
Time is not.
Was there any dying declaration?
Yes, oral dying.
There are two.
Oral,
Before
oral.
PW7
These are not
and 8.
recorded.
No.
Not
PW7 and PW8.
PW7
7 and PW8.
Okay. Who is PW7?
PW7 is one of the Dilip Kumar Rajak, one of the relatives.
Relatives. How is he related?
Complainant Naresh
Uncle-
Razak.
uncle's father-in-law.
Father-in-law.
Uncle's
Father-in-law.
What do you mean, uncle's? Who's the uncle?
Informant Naresh
Informant.
Rajak.
It is written complainant.
Uncle's father-in-law? Acha.
Means
What?
my
Uncle's
uncle's
father-in-law.
father-in-law. Means Dilip Kumar Rajak's uncle's father-in-law. Language has not been come out rightly.
The PW number 7, what is his name?
His name is Dilip Kumar Rajak.
Dilip Kumar Rajak.
Rajak.
So he's whose uncle? Or the informant is his uncle?
Informant is his uncle.
Informant is his
Yes.
uncle.
But
Okay.
it is written as
Uncle's
complaint-
father-in-law.
uncle's father-in-law. That means my uncle's, this informant is my uncle's father-in-law, not his father-in-law.
His uncle's
Uncle's
father. So that
father-in-law.
means that the deceased was his uncle or what? No, cannot
No,
be.
no,
Cannot be.
that cannot be.
Let us see. Let us see. Why don't you clarify these small?
Lordship,
PW number 7.
7.
Who is the uncle? We don't know. Where does it say? PW number 7.
7. At page 21.
Page 21.
21.
Complainant Naresh Rajak. Cannot be must be informant.
Informant.
Complainant
It
is
should be
informant. It should be
Naresh
informant.
Rajak is the informant.
Yes,
So is my uncle's father-in-law. Now who is his uncle? We don't know.
that is not mentioned.
So there is no connection.
Lordship,
He is an independent witness.
independent witness.
So that's what I'm trying to find out. So he's not a relative. You said relative, so that threw me off the
Lordship,
mark.
because the language has been written like this.
No, but then language may be anything.
Lordship,
But where's the question of he being a relative
Lordship,
of the deceased?
Lordship,
You see, when you said relative, then I tried to find a connection. There's no connection. Independent witness.
Distant connection is there.
distant connection.
What? There is no blood connection.
No blood
No,
connection.
no blood.
No blood
No,
connection.
no blood connection.
Okay, then PW number 8, who is he?
PW 8, he has said,
Prahlad
he is my father-in-law. Informant is his father-in-law. Informant is his father-in-law.
Informant's father-in-law. That
Father.
means
That means Prahlad Das is the uncle of PW7. It might be, my lord.
Lordship will find PW 8 at page
Yes,
number
sir.
24.
number 8. I know complaint. He is my father.
Father-in-law. Means informant is his father-in-law. He is relative. Son-in-law means.
That means the deceased is his brother-in-law.
Yes. Yes. Own
Brother-in-law of
relative.
deceased.
Own relative. Own relative.
If the informant is the father of the deceased,
Yes.
then this person is the deceased and this person
Brother-in-law.
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 The brother-in-law of deceased. Now, uncle's father-in-law, we don't know, whatever it is.
Yes.
So when it is uncle, that means uncle married to the
sister.
daughter, uncle's father-in-law of
Office not written.
is my uncle's father. Wait, is my uncle's father-in-law. Correct. So his uncle married the informant's
daughter.
Informant's daughter.
Informant's daughter.
Uncle married, but it is his uncle, not him. He did not marry.
He didn't marry.
So there's no relation.
No relation.
Okay, that's
PW7. Lordship. Lordship, may I read the evidence
Yes, yes.
come to the evidence of PW1? On 13/1/2013, at about 9:10 p.m., I, along with my deceased son, returned from our shop towards our house. When we arrived near our house, I was proceed ahead of my son on foot, and my son was come on foot. It will be foot, not foot. When I arrived near my house, suddenly I heard shouting of my son. I saw towards back and saw that accused gave knife blow on the stomach of my son and on the back of my son. I saw injury on the stomach and backside of my son.
they should say stabbed.
Yes.
What knife blow? Stabbed.
Stabbing, it will be stabbing.
Okay, then
I saw injury on the stomach and backside of my son. My son immediately fell down and became senseless. The accused, after giving knife blow, fled away from the place of occurrence. By hearing hue and cry, nearby people gathered and arranged a vehicle and took me to Assam Medical College, Dibrugarh. My son was under treatment for 2 days in Assam Medical College, and on 15/1/13, he died in Assam Medical College, Dibrugarh during his treatment. On 14/1/13, I lodged an Azahar in connection with this case. Exhibit 1 is the FIR. Exhibit 1 by 1 is my signature. Police recorded my statement in connection with this case. The whole incident has occurred in front of me. Cross-examination. I do not know who lodged the Azahar,
he's the
but he
person.
himself has lodged. Thereafter, interesting line, the second line, Lordship. I also do not know the contents of the Azahar. I have not stated before police that I was coming along with my son, but whether police has recorded this, I cannot say. In chief is stating that I was coming along with my son. My son was behind of me. I was proceeding ahead, but in cross he has completely changed this also. I have not stated before police that I was coming along with my son, but whether police has recorded this, I cannot say. Police did not ask me, that is why I have not stated before police that I was proceeding ahead of my son and my son was coming back on foot, and I saw that the accused gave knife blow on the stomach and back side of my son. Because police didn't ask, so he didn't say. At the time of occurrence, there was none except myself and my son. He has specifically stated that except he and his son, there was no other person. I know the accused. He is residing near my house. It is not a fact that accused did not kill my son. It is not a fact that I have falsely implicated the accused person. So this is the evidence of informant father. Thereafter, Lordship, PW2 at page 10, Sumit Kumar Rajak, whose name has been stated by the informant in the FIR, that he was along with his deceased son. I know the accused person. He resides near our house. I also know the informant Naresh Rajak. I also know the deceased Jitendra Rajak. The incident occurred about 2 years back on the day of Magh Bihu. On the day of occurrence at about 10 to 10:30 p.m., I went to grocery shop to buy betel nut at Dhobi Patti. That shop is near the house of deceased person. I went to shop along with Rajiv Mahato and Munna Rajak. When we returned from the shop and crossed about 50 meters, that is about 1 foot, we heard someone shouting from backside. We rushed to that place. In the front side of the shop where purchased betel nut, we saw the accused Azizur Rahman stabbed deceased Jitendra Rajak in his belly. As we reached the place, the accused fled away by his motorcycle. We immediately called and took the deceased to AMCH Dibrugarh. The deceased got admitted to casualty department and thereafter he was taken to surgery department.
Is this evidence recorded in the vernacular?
No, Lordship, because the signatures are in
Signature is
original.
there.
Okay.
Signature is in original. This has been.
Okay, then carry on.
Lordship, police recorded my statement. Police also brought me before the magistrate to record my statement. Exhibit 2 is my statement before magistrate. Exhibit 2 by 1 is my signature. Thereafter is cross-examination. This is Jitendra Rajak is my paternal uncle. He is not, it is not a fact that I came after the incident. It is not a fact that there are other two persons, Rajiv Mohato and Munna Rajak. It is not a fact that I deposed false, as Jitendra Rajak is my uncle. The place of occurrence is road which connects to Mathauri E and D. That means E and D has been shown in the sketch map. Besides V3, other person, namely Dipu Shah, he has been examined as PW4. The owner of the shop was present. There were other two persons. I could recall three names right now. There were electric lighting in the street post as well as in the shop. It is not a fact that at about 10:30 p.m. there was no electric light in the street and the shop. I saw dagger in Azizur's hand. It is not a fact that I did not see any dagger at Azizur's hand. It is not a fact that on that day we quarrel among ourselves and the accused is not involved in this case. It is not a fact that I stated before magistrate as tutored by police and my other relatives. Lordship, his presence I will show by PW10 that he was not available at the place of occurrence.
PWC not available.
Yes, PW2, PW3 was not available at the place. I will read later on, Lordship. PW10. From there, it will be evident that they were with PW10 and some other persons on that day. Because it was a Magh Bihu, the festive season was going on, they were having some feast. That I will come, Lordship. Lordship, thereafter, Lordship will find the evidence of PW3 at page number 12. Munna Rajak. I know the accused. Naresh Rajak, informant, is my neighbor. I know the deceased. He died on 13/1/13. On that day at around 10:30 p.m. at 9, I along with Rajiv Mahato, Sumit Rajak, Avadesh Chaudhary has been examined as PW11, went to shop to purchase some goods. On the way to shop, I saw Munna Rajak, the deceased, and accused having some talks between themselves. They were talking loudly, but we rushed to the shop as it was getting late. Then after taking the things from shop, we came out from the shop and we heard someone shouted, and we turned back and saw that the accused who was stabbing the deceased with a dagger. I could see Jitendra Rajak was standing towards my side and Aziz Ali, Abdul was cut, thereafter it was written, Aziz Ali was standing towards my right. I could see the accused stab the deceased with the dagger clearly as there was street light. Then seeing the same incident, we rushed towards them and the accused fled away from the place of occurrence in his motorbike. Then we took Jitendra Rajak to a nearby veranda of Manoj Rajak. Then we called for 108 and took him to hospital. Then he expired in AMCH on 15/1/2013 in the morning hours. Police recorded my statement and I have stated before police as stated in the court today. My statement was recorded in the court. Exhibit 3 is my statement before magistrate and exhibit 3/1 is my signature. Cross-examination. The deceased who died was my neighbor. On 14/1/2013, police recorded my statement. I was all along with the deceased at medical. I have not stated before police that Jitendra Rajak and Aziz Ali were talking. I came to spot from shop on hearing shouting. I have stated before police that on the day of occurrence there was street light at the place of occurrence. It is not a fact that I have not stated before police that there was street light at the place of occurrence. But in the sketch map there is no mention of street light. I have not stated before police that accused fled away by a motorcycle. He has stated that he had not fled away with the motorcycle. He had admitted that fact. I do not remember when I came to court. I have stated before magistrate in the court that altercation took place between Jitendra Rajak and Aziz Ali. It is not a fact that I have deposed personally in the court today. It is not a fact that I have not seen the occurrence. I have seen the occurrence from the distance of 60 to 70 meters from the place of occurrence. The place of occurrence is road which connect the river bridge. It is not a fact that I have deposed falsely. This is the evidence of PW3.
I wonder sometimes if they know the questions that are being put to them.
That's it.
And whether the answers have been correctly recorded.
That also lordship doubtful. Sometimes we also find regard while doing the trial of the cases.
Because the evidence should be recorded in the vernacular also if it is,
Lordship.
if it's required.
Lordship.
You don't have to do it in English.
Yes.
Because if the witness don't understand, I don't know, sometimes there's a lot of inconsistencies here.
Lordship.
And I'm quite sure it's either because of the persons who are recording it or the persons who are giving evidence not understanding the questions or being able to express themselves correctly.
Because the questions are asked in vernacular only, but it is writing only part is
Now
done in.
they won't know what is being written. No? That is
Lordship,
the
that,
problem.
that is the problem. Because they have been asked, the evidence will be recorded.
And if the counsel for the if the PP or whoever is representing the informant, if they are not very adept or not well conversant in English, then they also might not know exactly the import of what's being written down. Anyway, carry on.
Lordship. Lordship, thereafter the evidence of PW4. Deepu, Lordship will find at page number 15, Deepu Shah, the shopkeeper, the owner of the shop. I know accused Aziz Ali. I also know the informant. I know the deceased Jitendra Rajak. The deceased died on 15/1/2013. The incident occurred on 13/1/2013 at around 10:30 p.m. At that time, I was closing my shop. 4 boys, namely Sumit Rajak, Munna Rajak, Abades Chaudhary, Rajiv Mohato, came to my shop to purchase something. I heard a shout from outside my shop. Then I came out from my shop and saw Aziz stab the deceased Naresh Rajak with a knife on his stomach 3 times. The incident occurred at a distance of 30 meters from my shop. Then Aziz Ali fled away from the place. Then he ran away from the place of occurrence in a bike. Then we took Jitendra Rajak to a nearby shop of Manoj Rajak and made him sit in the veranda, and then we called 108. Then the above named 4 persons were also present in the place of occurrence. Then he was taken to AMCH where he
Evidence of PW4 is
Lordship.
quite straightforward, not shaken also.
Lordship. But Lordship, I will show Lordship, because there are some inconsistency between the medical injuries and the injuries which has been stated by the persons dealt to the deceased. That I will show Lordship, because from the post-mortem it will be clear, Lordship. I will show. Then he was taken to AMCH where he succumbed to his injury on 15/1/2013. I have seen the knife which was used by the accused Aziz Ali to stab. Police recorded my statement in the police station, and I have stated before the police as I had stated in the court. I was also brought before the magistrate to record my statement. Exhibit 4 is my statement. Exhibit 4/1 is my signature. Cross-examination. The road of Dhobipatti is ahead from my shop towards near River Dike. The place of occurrence is the backside of the house of Santosh Thakur. Santosh Thakur not examined. The boys, namely Sumit Rajak, Munna Rajak's house is situated at left side of my shop. The road of Dhobipatti is less than 1 kilometer. It is not a fact that I have deposed falsely in the court today. It is also not a fact that I have not seen the occurrence. It is not a fact that what I have stated today is tutored to me. Thereafter, at page number 17, PW5, Deepak Das is a Lordship Caesar witness. I know the accused person. I know the informant Naresh Rajak. The accused resides near my landed property. I know the deceased Jitendra Rajak. The incident occurred around 2 years back. I came to know from my neighbor, whose nickname is also Alu, that the deceased was killed by accused Aziz Ali. Then police met me near the house of the informant. I saw police taken out a knife from the house of the accused and the knife had blood stains and police seized the same in my presence. The knife was not sent to serologist expert for examination. Police seized the said knife oblique dagger and I identified the said knife to be one which I have seen in the court today. Material exhibit 1 is the said knife which I have seen in the court today. Exhibit 3 is the scissor list. Exhibit 3/1 is my signature in the scissor list. I put my signature in the scissor list cross-examination. I have not personally seen the occurrence. Police did not ask me as to how the incident occurred. Police only took my signature. Exhibit 3 is written by police and I put my signature on Exhibit 3. Exhibit 3, the seized articles was carried by police. I do not know as to who the owner of the seized knife. He has said that police had carried. I do not know who is the owner of that knife. It is not a fact that the knife which is seized by police is the same knife which I have seen in the court today. I put my signature first on Exhibit 3 and then by other witnesses. Exhibit 3, scissor list, is written by police in front of me. It was written at the place of occurrence. As police did not ask me, so I did not tell police from whom I came to know about the occurrence. Thereafter, Lordship, PW6, page number 19, Rajiv Mahato. I know complainant Naresh Rajak. I know the accused. I came to know deceased Jitendra since after the incident. The incident took place some 7 years ago at about 10:30 p.m. On the day of the incident, I was returning along with Sumit Rajak, Munna Rajak and another boy after purchasing some stuff from a shop near the school. After covering some distance, I saw that accused Aziz was stabbing Jitendra Rajak on his abdomen with a knife. At that time, street lights were on. Jitendra fell on the ground. After assaulting Jitendra, the accused fled the scene. A hue and cry ensued. On being informed by someone, 108 ambulance arrived. The wounded was taken to the hospital in 108 ambulance. 2 days after that, I came to know that the wounded had died. Police examined me. Police brought me to the court. I made statement before a magistrate. Exhibit 5 is the statement which I made before the magistrate. Exhibit 5/1 is my signature therein. Cross-examination. My house is in Amlapati Gurudwara, Gurudpara. The deceased person's house is near Amlapati High School. I don't know the name of the shop owner from whom I had purchased stuff. It is not a fact that I did not witness the incident. It is not a fact I made statement before the magistrate as tutored by police. It is not a fact that I have adduced false evidence. Thereafter, Lordship, the evidence of PW 7, Dilip Kumar Rajak, PW, page number 21. Complainant Naresh Rajak is my uncle's father-in-law. The deceased is the son of the complainant. I knew him. I don't know the complainant. One day, some 4 years ago, in the year 2013, while Jitendra was being brought in an injured condition to Casualty Department of Assam Medical College and Hospital, I also arrived there. I saw wound in the left side of his abdomen. His clothes were soiled with blood. After treating him, the doctor forwarded him to the ICU. Jitendra died the following day. While Jitendra was being treated in the casualty ward, he was able to speak. On being asked as to who assaulted him, he replied that Aziz, his neighbor, stabbed him with a knife. I was present while police was holding inquest on the dead body. Exhibit 6 is the inquest and Exhibit 6/1 is my signature therein. Lordship, in the inquest, I will show there is some other story, Lordship. The incident took place on 13th day of a certain month in the year. Cross-examination. The incident took place on 13th day of a certain month in the year 2013. Police did not examine me. It is not a fact that the injured was not in a state to speak. It is not a fact that the injured did not state that Aziz had stabbed and injured him with a knife. It is not a fact that police examined me. It is not a fact that while making statement, I state to police that certain unknown person stabbed Jitendra with a sharp weapon, thereby injuring him grievously. This was the statement given before the police and in the inquest report which has been exhibited through him. It is not a fact that since the complainant is my relative, I depose for his sake. Thereafter, at page 24, PW 8, Prahlad Das, before whom also there is a dying declaration. I know complainant Naresh Rajak. He is my father-in-law. This is Jitendra was my brother-in-law, wife's younger brother. I don't know the accused person. I am the chokidar of ladies hostel number 2 of Assam Medical College. I was on night duty on 13th of January 2013. After having meal at home, I reached hostel at 10 p.m. for my duty. My eldest son called me over phone and informed Jitendra Mama was hacked by someone with knife and he was being brought to the medical. Informing the monitor of the hospital about the incident, I went to the casualty department. Meanwhile, the injured had arrived. Taking him down from the 108 ambulance, we took him to the treatment room. There was wound in Jitendra's abdomen. His clothes were soiled with blood. Doctor treated him. He was taken to X-ray department. After the X-ray was done, he was taken to surgery department. When the injured had reached the casualty department, he was in a state to speak. When he was asked as to what has happened, Jitendra replied that a boy by the name of Aziz, who happened to be his neighbor, assaulted him with a knife. The injured died in the morning of 15/1/2013. Police came, examined the dead body and prepared documents. Exhibit 6 is the inquest report, wherein Exhibit 6/2 is my signature. Police examining me. Cross-examination. It is not a fact that I did not state before police that at the time of arriving at the casualty department, the injured was in a state to speak. When I asked the injured, he said that one boy by the name of Aziz who lives near his house had stabbed him with a knife. It is not a fact that the injured was not in a position to speak. It is not a fact that since the deceased was my brother-in-law, I have adduced false evidence in his favor. Police did not produce me in the court. It is not a fact that while giving statement to police, I state that certain unknown person had wounded him. Thereafter, Lordship, this is the evidence, and he has also his statement is also there. And in the inquest report, he has stated that some unknown person has done that. Thereafter, Lordship, PW 9, Muzamal Ali, page number 27. I know complainant Naresh Rajak. I know deceased Jitendra Rajak as well as the accused person. The incident of this case took place one evening during Bihu in the year 2013. In the evening on the day of the incident, as I was returning home from work, I saw a large gathering of people on the road near my house, and I too went there. People were saying that someone had assaulted Jitendra and left. Police arrived. On being asked, I said that I did not witness anything. Police asked my name and address and took my signature on a piece of paper. Exhibit 3 is my signature in the Exhibit 3, that is the seizure list. Lordship, he has been, with the permission of the court, he has been declared hostile. At this stage, prosecution prays to declare the witness hostile. Perused in so-and-so once again, prayer is allowed. Cross-examination. It is not a fact that while making statement to police, I said on 13/1/2013, while Jitendra Rajak was returning home, after closing his shop, he started chatting with accused Muhammad Aziz Ali and another of his friend at the gateway of his house. And in the course of their chat, when Jitendra Rajak said something to the accused Aziz stabbed Jitendra Rajak in his abdomen 2 or 3 times with the knife, which Aziz had been carrying, and fled from the scene. Immediately, Jitendra was taken to Assam Medical College Hospital with the help of the villagers, and he died while under treatment there. Police seized the knife which had been used by the accused Muhammad Aziz. I put my signature in seizure list. It is not a fact that I witnessed the incident through my own eyes. The accused person's house is about 200 feet away from that of mine. Jitendra Rajak's house is on the opposite side of my house. I have good relationship with the accused person from before, as he happens to be my neighbor as well as friend. It is not a fact that for the sake of the accused, I have adduced false evidence concealing the truth. Cross-examination by defense. I did not witness the incident myself. I do not know where police found the knife which they seized. I drank a little bit of liquor every evening. At the time of incident, I was a bit intoxicated. I did not state to police whatever is there in the statement read by the public prosecutor today. It is not a fact that for the sake of the accused, I have adduced false evidence concealing the truth. Further examination, I cannot say whether material exhibit 1, that is the knife, is the one which I saw on the date of the incident. Thereafter, Lordship, at page number 31, the evidence of PW 10, Rahul Rajak. I know complainant Naresh Rajak as well as accused Azizur Rahman. This is Jitendra Rajak was the son of the complainant. The incident of this case took place at the time of Magh Bihu in 2013. I, along with my friends, Munna, that is PW3, Munna Rajak, thereafter PW2, Sumit Rajak, Babu, Amit, and a few others, was having feast in the paddy field near our house. Babu appeared, Babu not examined, and told that Aziz had assaulted Jitendra. Then we came out to the road. The road was crowded with people. Jitendra was lying on the road. There was blood on the ground. Jitendra was taken to medical in an ambulance. Police arrived after a little while. Police took my signature on a piece of paper. Exhibit 3/3 is my signature on Exhibit 3, the seizure list. Cross-examination part. I did not witness the incident myself. Police asked me my name. I do not know what is written in Exhibit 3. Police did not show me anything. Lordship, if this is taken, then Lordship, the presence of PW3, PW2 at the place of occurrence is doubtful. Thereafter, Lordship, PW3, Avadesh Chaudhary. Oh, PW11, Lordship, whose name appears in the evidence of the other witnesses, but his evidence is somewhat different. I do not know the complainant. However, I know the accused as he is my neighbor.
No, you were saying with PW10
Yes, Lordship.
that he was having feast with his friend Munna, Sumit,
Yes.
Babu, and so.
Yes.
How does that have any relation, bearing with the fact that
Their presence
they
at the-
were not present at the site?
Because at that time, Lordship, they were having feast, and they have
No,
stated.
who is this Munna?
Munna means PW3, Lordship, and Sumit Rajak means PW2, Lordship. I will go to PW2, Lordship.
PW3 is Munna Rajak.
Yes,
So we do
Lordship.
not know which Munna is this.
Lordship.
This is, there can be 2 Munnas, 3 Munnas, 4 Munnas also.
Because name are similar, Lordship, Munna and Sumit.
Name might be similar. How many Borgohines are there? How many Barwas are there?
But villages, Lordship, the story might be different
I
because.
don't know, because it doesn't give the full name.
Lordship, they have stated Munna and Sumit.
Munna and who?
Munna is PW3, Lordship, and Sumit is PW2.
How do you say that? How do you know?
Because, Lordship, from the
Full name
it
is not
similar.
given.
Title is not given.
And Babu, who is Babu? And who is
Babu
Anu?
not examined. Because Babu has stated, it has been stated that Babu appeared and told us that Aziz had stabbed Jitendra. Then we came out to the road. We means all of these persons, including Munna as well as Sumit.
Munna, Sumit, very common name.
Lordship, but in village, Lordship, I can't say that.
Yeah. Chotu also will be very common name.
I will try, Lordship. What can I
Yeah,
do,
it's
Lordship?
okay.
Thereafter, Lordship, PW11, Avadesh Chaudhary, which the other PWs have stated that they were also, he was also present with them. I do not know the complainant. However, I know the accused as he is my neighborer. The incident took place about 5 or 6 years before. I have heard that the accused, namely Azizur, had committed murder of some person. Police came to our place and inquired about the occurrence. Other than that, I do not know anything. My statement was recorded in the court before the magistrate. Exhibit 4 is my statement. Exhibit 4/4 is my signature. Cross decline.
12 is the doctor.
Lordship. 12 is the Dr. Lordship. PW 12 at page 34. On 15/1/2013, I was working as assistant professor at AMCH, Dibrugarh. On that day, I have performed postmortem examination on the deceased Jitendra Rajak, aged about so and so, resident of so and so, identified by so and so. Naresh Rajak, the father of the deceased. On examination, I found the following external appearance: one so and so, male, dead body naked, so and so, eyes closed, mouth closed, rigorous mortis present all over the body, postmortem staining faintly present on the back. Injury number 1, one surgically incised over right paramedial.
Okay, we got it. So we got it. So you have got anything to say
Yes,
with regard to the
Lordship.
injury?
Yes,
Which
yes,
one?
Lordship.
Which one?
Because, Lordship, if we come to the evidence of whatever we have come, all have stated that a stab injury has been given by our accused, the appellant, with a knife. But if we go to the injuries, Lordship, the injuries are on the upper side, chest, back of the chest, ribs, and thereafter in the nipple side, Lordship. Then
So-
how can that come, Lordship? Because
You mean to say the evidence shows that only one stab wound should have been there?
no,
according to
only
you?
in the stomach, Lordship. But from the injury, whatever is there, there is not a single injury in the stomach. All are in the chest part, upper part. Thereafter, Lordship. Then, Lordship, there is a doubt that whatever they are stating, because all are stating with a knife blow in the belly, in the stomach. But if you, Lordship, see the stomach part injury, there is nothing.
Well, you see, when you hit somebody, it might look as if they're hitting somewhere here in the stomach because it will go like this, from down to up.
Lordship, because in a serious offense like murder, Lordship, when all are stating that they have if we, for the sake of argument, we believe that they have seen it, then Lordship, how can the injuries be different, Lordship? Because all are stating that stab injury in the stomach. Every, if you're, I will read the injuries, all are in the upper part, Lordship. And in the rib part, Lordship, how can that be, Lordship? Because every injury is showing the chest, and Lordship, may I read the injuries, Lordship? There are 6 number of injuries, Lordship. And all are saying only about one injury in the stomach and belly, Lordship. How can that be, Lordship? If they have stated they were present, they have seen the occurrence. In the backside, how I will hit, Lordship? In the backside also there are injuries. They are stating that I have given a blow only in the front of the stomach or the belly, but there are injuries in the backside also, in the chest part also. How can that be given by one person at the same moment, Lordship?
Why not?
Because, Lordship, all are stated that they have seen the incident. All the incidents are stating only one part, that is belly, Lordship. But in the belly or stomach, there is no injury, Lordship.
No, it says here also, this PW1 also says,
Lordship.
I saw that the accused gave knife blow on the stomach and backside of my son.
Lordship, but if we go,
Backside means-
no, Lordship, I will come to that, because if we see the cross-examination of PW1, his presence is doubtful, Lordship, because he himself stated that I have not stated before the police, Lordship. First time in the court, how can that come, Lordship, then? Because if we go through his evidence, if we believe PW, whatever he is stating is gospel truth about PW1, then he has specifically stated, Lordship, that except him, there was none other. Then how come this person see, Lordship? Which person is to be believed, Lordship? Because one person is stately stating, Lordship, if you see the cross-examination part of PW1, he is saying that except me and my son, there was no other person, Lordship. Then how come these witnesses state that they were present and they have seen the incident, Lordship? Whose version is to be believed, Lordship, then? If we go through the informant's version, then he's saying in the backside and the stomach. If we go through the other, this PW4, 2, 3, 4, 6, then it shows that only one injury, Lordship, in the stomach, Lordship. Then how come these injuries come, Lordship? And that too in a serious offense like murder, Lordship. They have stated that they are the eyewitness, they have seen it. And in the dead of the night, 10:30, Lordship, only on the street light. And they have stated that they had seen the occurrence from 60 to 70 meters, Lordship. Whether it is possible, Lordship?
Why not?
If Lordship, no, for the sake of the, I am stating that whether, which version then to be taken up? One is the version of seeing the incident in the street light at 10:30 of these all the persons, and one person is available of his own son, own father, Lordship, who was accompanying. He is stating there was none except me, Lordship. How can that be, Lordship? Two persons. Which one is to be believed, Lordship? If we go through the version of this person, there is injuries that doesn't match, Lordship. And he have stated, if we believe PW1, he have stated that he has not stated those things before the police, Lordship. He doesn't know the contents of the FIR, Lordship. Which version is to be believed? And in the sketch map, there is no mention of any street lighting on that day, Lordship, because other things have been shown in the street line. That why not the street light, Lordship? Other things, whole description of the street, everything has been shown. The T state, everything has been shown, Lordship. Then why this relevant part? Because they are banking on the seeing the incident all through on the street light, Lordship. Source of light is not brought into the evidence, Lordship. There are two sets of evidences.
It could be that the moon was quite full.
That
How do you know? Did you cross-examine the witnesses to say that the night was pitch dark?
Lordship, we have cross-examined that there was no street light. That we have cross-examined. And that
Do you know that, there used to be a saying that in one of the states in Northeast India, that in the November moonlight, you can read a book.
Yes.
Under the moonlight.
Lordship. That part I can say, Lordship, at that.
This is.
We celebrate Rash festival in November and Purnima, that is the full moon day, my lord.
But
So what I'm trying to say is that you see that the moon sometimes is very bright.
Lordship, because
maybe you can see things far away.
No, Lordship, because if we see the date, it is 13/1. That means in the month of January, Lordship.
Correct.
January, the situation will be somewhat different, Lordship.
Maybe, could be, I don't know.
Could be, Lordship,
Could be.
Lordship, because in the deadly hours in the, Lordship, in the, that too in the village, whether the street lights only on seeing the person from 60 to 70 meters from
In
only
the
on the basis
village,
of
street lights hardly work.
That is the thing, Lordship.
No,
Then
but
how that can, Lordship?
but then they're still moving around in the dark. These villagers, they
But
can go
whether
here
it
and
is
there.
possible to see, Lordship, from that distance,
I
without
don't
any
know.
light,
I
Lordship.
don't know.
Because without any light, because everything has been shown specifically in the street light, road, everything, Lordship. But regarding the street light, there is no mention, Lordship. Then in a case of serious allegations like murder, Lordship, when there is no source of light has not been brought into specifically and proved.
You are speaking of which witness that way?
Lordship,
Which witness?
who has seen from the evidence of
You see, PW number 2.
Lordship, 10 to 10:30 p.m.
Yes, but
He has seen that after returning from the shop across about 50 meters, Lordship. He has stated regarding 50 meters, and in one of the cross-examination of one of the,
then continue reading.
Lordship.
We heard someone shouting from the backside.
Yes, Lordship.
We rushed to that place.
Lordship.
We rushed to that place means what? He went to the place of
Lordship.
occurrence.
It is the front of the shop. Lordship. He has stated that he has rushed. Thereafter, Lordship, it has come in the cross-examination of PW3. In page number 14, Lordship, I have seen the occurrence from the distance of 60 to 70 meters from the place of occurrence. Lordship will see the evidence of Munna Razak at PW3 at page number 14, who was also present along with them. He has specifically stated that I have seen the occurrence from the distance of 60 to 70 meters from the place of occurrence. All were present, equally available, they were at the same place, Lordship. And regarding the dying declaration, Lordship, if we see the inquest report, the story is somewhat different. Lordship, Exhibit 6, which has been exhibited through PW7 and PW8.
Page?
page 82, Lordship. And regarding the relevant portion, it appears on page number 84. Serial number 12, opinion of witnesses and police about the cause of death and weapons or instrument used thereof. Reportedly on 13/1/2013 at about 10:30 p.m. while he was coming to the shop belongs to Dipu Shah at Dhobipatti, Amlapatti, Dibrugarh. Some unknown 3 persons assaulted him with with sharp weapon, and on the same night he was admitted at AMCH Dibrugarh but died during the treatment of MSU.
So what is wrong? This is an inquest report. The inquest report is done by whom out here?
Lordship, but those has been exhibited. This document has been exhibited through this PW's Lordship. PW7 Lordship at witness.
You mean to say that the maker of this inquest
Yes.
report has not been examined?
Yes, because if we see the evidence of PW1 Lordship Prahlad Das, who has been examined, PW7, PW8, who has been witness to the inquest, Dilip Kumar Rajab, they have themselves been exhibited.
So what is the effect of the maker of a document not been examined to prove the document?
Because Lordship, then because as per the evidence, the contents have to be proved, Lordship.
Where? Which section?
Section 61 documentary, Lordship.
Section 61 of the Indian Evidence Act.
Yes, Lordship.
And if it is not proved by the maker, then what happens?
Then, Lordship, the evidentiary value will be weakened, Lordship.
Will be weakened?
Yes, Lordship, because the contents is to be true to the maker only. Because contents have to be proved as per the evidence through the maker, Lordship, who knows or who has the authority of the document.
And if it is not proved by the maker, then what happens?
Then, Lordship, the value of that document or that will be shaken, Lordship.
Value will be shaken.
Yes, Lordship.
Okay, then.
Lordship, basically these are my Lordship submissions, and furthermore regarding the injury part, Lordship, because all of them are saying that at the belly, but if your Lordship sees there are 6 number of injuries, they are stating only one step injury. All the injuries, no injury on the belly part, all the injuries in the upper part, near the nipple, near the chest. And if they have claims that they have seen, that they ought to have specifically also stated, because how then they can specifically say that injury has been given in the stomach, and that to somebody is saying 3 times. If there is 3-time injury, there must be some injury in the belly, Lordship. But if your Lordship sees in the belly, your stomach part, Lordship, only it is written pale, Lordship, and empty. Then there ought to be some injuries, Lordship, because if they claims themselves to be eyewitness, and they are very specific, Lordship, that with the dagger or with the knife, I have given the blow, and that too in the stomach. Then how come these injuries? They can see that I have given a blow in the stomach. Then how not to see that these injuries, Lordship? Only in the belly where there is no injury, they have claims that there is an injury. But from the postmortem, there is no injury, Lordship. Then how far it can be said that they have seen the occurrence, Lordship? Because there are 6 number of injuries in some other parts of the body, not in this lower part, Lordship. Because they are specifically stating that they have given the blow with my client or appellant has given the blow with the knife in the belly, Lordship. And one of the PW4 is stating that I have given 3 blows, Lordship. If they could see that, then how they ought not to claim of seeing those injuries, Lordship? How can that be, Lordship, in a serious injury case? They claim that they have seen it in the street light. If though not admitting, Lordship, they says that I have seen, we all have seen, we are there from 60 to 70 meters in the street light. If that is so, Lordship, then the injury, if they can see an injury given specifically with a dagger or knife in the belly, then they ought to have claimed that we have seen. But only this part, how can there is no injury, Lordship? How can that be so much of inconsistency with the medical, Lordship? Ocular ought to have given some support from the medical, Lordship, because it has been medically examined by a postmortem doctor, Lordship. He is stating somehow the other way around injuries, which is completely the other way around of the injuries stated by the witnesses on record, Lordship. If they claim that we have seen, yes, they have seen in the street light. if we do admit those parts also, then where are those injuries? They are stating in the stomach, in the belly, no injury, Lordship. How can that be, Lordship? If they can see that.
You are repeating two, three times, same thing. over
Lordship,
and over
because
again.
my the
It's like auto replay.
no, Lordship.
You see, earlier, you said this cassette
Recording,
recorder, yes, auto replay.
Because
So,
basically
I mean,
my
we
point
have
is,
heard it once or twice.
Lordship,
I mean,
Lordship.
it doesn't mean that you say it 10 times, then it.
Sorry,
we are-
if I have heard, Lordship, I'm sorry for that.
No, nothing. But you see, you are repeating the same thing over
Lordship,
and over
Lordship,
again.
Lordship. Basically, on those points, I pray for acquittal, Lordship.
Lordship, here are 1, 2, 3, 1, 2, 3, 4, 5. 5 eyewitnesses are there, the Lordship. And who happen to be the same locality. They used to know that Ajijur by name, they used to know, my lord. So even if there is the contention of the appellant, that there is no light or so, the village people, they by appearance also they come to know, your lordship, who is who, your lordship. And there are dying declaration to that effect, your lordship. And my, if I could understand properly, is that there are inconsistencies as regards medical evidence as well as ocular evidence, your lordship. When there are two sets of witnesses, your lordship, two sets of evidences over medical, ocular evidence will prevail over the medical evidence, your lordship. What did I may I'll show my. Lordship, can you see para 8 and 9? I'll get it Xerox and give it to your lordship.
Which para?
Para 8 and 9.
No, it does not say that primacy has to be given to the medical evidence.
No, your lordship, no. When ocular witnesses are there, eyewitnesses are there, your lordship will give more credence to those witnesses.
To the
He's
eyewitnesses.
saying that.
To the eyewitnesses.
Yes, rather than medical witnesses, medical evidence. But your lordship, may I take your lordship to the inquest report, my lord, as at page 82. Page 84 is relevant portion. Chest left side injured under cover of bandage, then thereafter stomach, your lordship, page 84. Injured in right back under cover of bandage. So injury was on there in the stomach, your lordship.
Madam,
In the inquest.
one thing.
Yes.
He says that the maker of this report has not been examined to prove the document.
Maker of what?
The inquest report.
Lordship, it may not be, my lord.
Right?
And your lordship, if your lordship leaves apart the inquest report and PM report, your lordship, stomach is filled with blood. May I take your lordship to the post-mortem report? Page 90. Page 90, my lord. Peritoneum filled with liquid blood, clotted blood, approximately 1 liter. Then pleury, at serial number 2, your lordship. It's a lordship organs just nearby our stomach, your lordship. So it may not be appropriate like in the stomach on the belly.
What do you have, what do you say with regard to, what have you got to say with regard to the cross-examination of PW1?
PW1, your lordship,
Father.
father. May I see the 161 statement your lordship permits?
Yes.
May I
yes,
check
yes.
his statement on the 161?
PW number one is the one
Narration,
who
the
lost
father.
the
Yes, he's the father.
FIR.
Yes. May I, it's vernacular, I'll try to translate. Statement of complainants in Naresh Raja, so and so. Eo mur gusoria, mur gusoria hoy. Eo khudhat, lordship, somebody else has written here, lordship. The police has maybe asked him. Khudhat koi je mur nam thikona uporot diar, bottoman moi ghorote, so and so tarikhe rati pa dostam, so and so. May I'll translate the relevant portion.
This evidence is taken in English or in?
In Assamese,
Assamese.
not evidence, 161 statement.
No, what about the evidence?
Evidence is in English, my lord,
English,
because
English.
his signature
Signature
is
is
there.
in original, in
Original.
Assamese.
But he has given his signature in vernacular.
Vernacular.
যোৱা ইংৰাজী 13 তাৰিখে ৰাতি প্ৰায় 10:30 মান বজাত গুচৰিয়াৰ ল'ৰা জিতেন্দ্ৰ ৰজক বজাৰত দোকান বন্ধ কৰি ঘৰলৈ আহি থকা অৱস্থাত লগত আহে তেওঁৰ বন্ধু ৰাজু মাহাতো, মুনা ৰজক আৰু সুমিত ৰাজকৰ সৈতে আমি আহোঁতে অৰ্থাৎ ওচৰৰে মহম্মদ আজিজ আলী আছে. So he is a neighbor. Aziz is the neighbor, your lordship. So it's a natural, your lordship, that they will know. Because the informant knows him, my lord.
Yes.
Yes. So on at 10:30 p.m., your lordship, on 13/1/13, while after closing, your lordship, they were coming along with Raju Mahato, Munna Razak, and Sumit Razak. Suddenly, your lordship, Aziz attacked the victim, my lord, Muhammad Aziz Suka Australia with a sharp weapon.
That is a statement.
Yes.
Made.
Yes, my lord. So in the substantive lordship, whether it is for the first time in court or it was already given to the police, your lordship. That I wanted to see, your lordship.
Okay, assuming that what has been stated
Yes.
under 161
Yes.
is similar to the examination in chief.
Yes.
Evidence recorded.
Yes.
But what happens to this evidence given in the cross?
Actually, my lord, probably he doesn't know how to read and write. Just he knows how to like give a signature, because it was not in a direct form, my lord. He was dictating somebody and somebody else was writing. Because it's not in direct form.
Now, but what to do?
We can assume.
What to do?
No, it's there because it's like.
No, madam,
Yes.
we have got to take, we have got to consider the cross-examination
Yes.
also.
As a whole, chief as well as,
Naturally.
yes.
Now what to do?
At the time, there was none except myself.
At the time of there was none except myself and my son. Whether this part, while recording the statement by police, there might be two interpretations, my lord. Whether at the recording time, when the police has recorded the statement, he was alone, or at the time of occurrence, he was alone.
No, at
that
the
is not
time
the
of
issue.
occurrence, there was
Oh,
none
oh,
except
yes,
myself.
yes.
Specifically
This
stated.
is a
Yes,
cross-examination.
Yes.
Yes.
Cross-examination. is
In
to
the-
be
in
So
the
your
trial
lordship, if
before.
there is no one, only this person was there, your lordship. So it's enough, your lordship, even if one witness is, who is the confidence of this honorable court, it's enough, your lordship, there witness, evidence of one,
No,
only
no,
one eyewitness.
Madam, you're not understanding.
My lord,
You see, in his examination in chief,
yes,
he speaks of his son going coming back
Coming
from a
back.
shop.
yes,
Okay.
along with others,
Along with others.
yes,
However, when you read the cross,
yes.
Yes.
it says that at the time of occurrence, there was none except myself and my son.
No, somewhere I found these two persons were at the, going forward. Lordship, yes, there are two persons, my lord. They were at the back doors. Other witnesses, they just turned back and saw. They heard a sound, my lord, and that time they saw.
It's not a question of law, basically.
My
I'm
lord.
asking you. You see that the problem is now what will this court do
My lord,
if there is a contradiction in the evidence adduced during cross-examination and examination in chief? What should this court do? You
so I
advise us?
said, your lordship, other
Lordship, because-
witnesses who have just, lordship, other eyewitnesses are admittedly there. At the back, this informant as well as the victim were like proceeding.
Admittedly there according to whom?
Because the other witness doesn't speak about this
We'll
other.
forget about the other witnesses for
Yes,
the time being.
my
Only
lord.
PW1.
Yes,
PW1 in his examination in chief has said that the others were there. In the cross-examination, he said no one was there.
lordship, may I repeat it once again, once more? Slowly I'll read if something comes up. I know the accused person. I am the informant of this case. Deceased Jitendra Razak was my son. On 15/1/2013, my son died in Assam Medical College and Hospital, Dibrugarh. I have a laundry shop at Kole Road, Dibrugarh. On 13/1/13 at about 9:10 a.m., I, along with my deceased son, returned from our shop towards our house. When we arrived near our house, I was proceed ahead of my son on foot, and my son was on
Was
foot.
coming on foot.
When I arrived near my house, suddenly I heard shouting of my son. I saw towards back and saw that accused gave knife blow on the stomach of my son and on the back of my son. I saw injury on the stomach and back of my son. My son immediately fell down and became senseless. The accused, after giving knife blow, fled away from the place of occurrence. By hearing hue and cry, nearby people gathered and arranged a vehicle and took me to Assam Medical College, Dibrugarh. My son was under treatment for 2 days in Assam Medical College on 15/1 so-and-so. He died in so-and-so, Dibrugarh, during his treatment. On 14/1/13, I lodged an Azahar in connection with the case. So exhibit 1 is my signature. Police recorded my statement in connection with this case. The whole incident has occurred in front of me.
Now, madam.
Yes.
Come to the Azahar.
Yes. Yes. May I see the original form of the Azahar, your lordship? I think it's all the same.
Original one only, Lordship,
Original
because
one.
signatures are original. Okay, right.
Okay. So the same in English only.
It is in English only.
Yes. So what was your lordship's query as regards the Azahar?
Please read the first
Yes.
4 lines.
I have the honor to inform you that yesterday at night about 10:30 p.m., while my son Jitendra Razak was coming from shop by purchasing some household goods with his friends, his Raju, Muna, and Sumit Razak, suddenly one Ajiz Ali along
No,
with
he
his,
was with his friends.
Yes.
he was with his friends. He was coming towards home.
With his friends.
Yes. One
Hello.
Ajiz Ali, along with his 2 unknown associates, attacked on my son with deadly weapon. iron rod and dagger, big knife, and put it 3 times in his belly, in stomach, and due to which he sustained grievous injuries on his stomach, due to which he became senseless. Thereafter, he also threatened the other friends that if they do anything for saving him, he will kill all his family members. That's sir, I, with the help of local people, admitted my son in the Assam Medical College and Hospital, where he is admitted in the ICU.
So it appears from this
Yes,
that the three friends were there at the time of the
Yes.
incident.
yes,
And they were also threatened by this
Aziz,
accused,
appellant.
by the
yes,
appellant.
yes.
However, in his cross-examination, he has said that no one was there.
My lord.
Only he and his
Lordship,
son.
in that regard, may I say there might be omissions here and there, your lordship.
How can that be?
There can be omission, there can be exaggeration. So your lordship will
says
take
here-
out the shape from the grain, your
It says
lordship.
here, at the time of occurrence, there was none
None
except myself and my son.
Yes, my lord.
Specifically stated, Lordship.
How do we?
Lordship, there might be, so I said, there might be two parts. This victim was coming along with his friends. Lordship, this informant was proceeding ahead of the deceased, my lord. Suddenly he heard a sound and he saw the accused person assaulting and fleeing away.
Can we go by what you say or by what is?
Whatever is there on the
recorded by
record.
time?
No, your lordship, his evidence said, your lordship, his evidence says so. They were proceeding from the market along with the sons, along with the deceased, my lord. And your lordship, from the evidence, it says, your lordship, this victim was behind the this one informant.
But friend's name were not stated, Lordship.
Just a minute. Yes, anything
Yes,
else?
behind the informant. He heard the sound, he turned back in and he saw, your lordship, this accused person attacking and fleeing away. So there might be some little bit of omissions, your lordship. I don't know on which date it was recorded. It was recorded in 15. Incident is of here.
Incident of here 13.
13, 2 years have gone by the time, your lordship. I understand there might be something, my lord. Omissions on the part of the.
But Lordship, whatever
And
is
there's
there on
nothing
the
to
record.
disbelieve, your lordship. There are so many eyewitnesses are there. Oral dying declaration is there. And your lordship, the medical report as well as your inquest report talks about the injury part.
Medical report, Lordship, the blood has
It's on the
been come
belly.
in the-
Just a minute, Mr. Counsel, let
Lordship.
us see.
Lordship.
Your time will
It's on the
come.
belly and pleury, your lordship, it's near the stomach only. So like, although it's not precise that the attack on that part, so but it's in and around the belly, your lordship. And blood clot was also there on the belly, your lordship. Blood was there. Internal bleeding is there in the belly. PM says it's filled with liquid blood, my lord. Even Caesar was also done, your lordship, at page 74.
What about the incident occurred around 10:30
Yes,
at night?
yes.
There was no light.
So I had a judgment, my lord. If it's from the same locality, lordship, even if there is no light, your lordship, they'll assume that this person is they'll assume, lordship, by image also, your lordship will
If
put
it is around 60 meters away, then
60 meters and my lord. I doubt, but still, my lord. And a village area, your lordship, village area, the shops were there, my lord. It's not that all the shops were closed, about to be closed, my lord.
This
Little
shop
bit
is
of,
closed.
about to be closed because it's a 10:30.
so in the village area, shops close at what time?
Sometimes early, nowadays, I don't know.
It is
Sometimes
early only
like-
because in
In village
times,
area, they sleep very early.
very early, Lordship.
Now the things are changed. In Shillong nowadays, I found nightlife is also there. Before it was like 5 o'clock, all shops used to close.
We're
my
not talking about nightlife. madam.
No, your lordship, shops and all.
Because on that Lordship, there was Magh Bihu. So in the Magh Bihu, shops normally remains closed.
And
Lordship.
Magh Bihu people are there, your lordship, on the road. We
Okay,
celebrate
Magh
Bihu.
Bihu time.
Yes, Magh Bihu time people are on the road, my lord. Because lots of celebrations, my lord. 13-1, 13-1, 14-1, we celebrate Magh Bihu all the time. So people generally remains on the road or outside, my lord.
And there'll be a lot of houses will be full of lights.
Yes.
I mean, the
Yes, yes.
houses might not be street lights, but the
Yes.
light from the houses
Yes,
will be there.
yes.
But there is nothing on record, Lordship, that
We
regarding
like,
what is there.
we burn
Lordship.
firewoods, my lord, on Magh Bihu.
Because in
No,
village
but then
areas, the festive.
you have not asked them whether the houses were all dark or not.
Lordship, because in the village area, most of the feasts will take place in the fields only because there is a festival
In
of
the
mud.
field.
Yes, Lordship.
So if it takes place in the field, how will they know what they're eating? There has to be light.
No, in the field, Lordship. An incident is near the road, Lordship. They have said.
How will they go back home, those people, after eating?
Because if we go through the evidence of PW 10, Lordship, then the presence of these two witnesses are also doubtful, Lordship. That I have stated, Lordship.
Because they're eating fish.
Lordship. And furthermore, the injury part, Lordship, because the blood has come in the belly, but the injury is none of the single injuries in the belly, Lordship.
You see, those are minor things because you see, they saw him hitting around the belly area.
Belly.
Now, belly area doesn't mean that it goes directly here, can be little bit here, little bit here. What does that mean?
Because this is in the upper part, Lordship.
Upper part.
Injury part, upper part, near the nipple, they are stating.
No, it's a diaphragm also. Diaphragm is
Yes.
still here.
Yes.
Diaphragm is still here.
Okay.
If someone stab you here, then if you say belly also, it doesn't make it. I mean, it appears to be the belly only. It's a diaphragm. Near the diaphragm. Anything else?
Lordship, regarding embellishment, contradiction, inconsistencies, and upon judgment. So your Lordship will take out shape from the grain, your Lordship, while arriving at a conclusion. My lord.
Regarding the evidence of PW1, he is consistent regarding the presence of only the father and the son. And the other persons also never say that the father was available at the place of occurrence, the other witnesses. Because the father has specifically stated that except me and my son, there was no one. And we go to the evidence of the other witnesses. They have not spoke that the father was also available at the place of occurrence. Because father is all the round, he is stating that I alone with my father were available, with my son was available. And in the evidence of the other witnesses, it comes only of presence of those persons, Lordship. The father was not present then. Whose evidence is to be believed, Lordship? Because father and son were going ahead, he is stating specifically, Lordship. Because whatever is there in the record, that is to be seen, Lordship. How can we presume in a murder case, Lordship, that there he was moving ahead? Because the father doesn't speak of the presence of the friends, Lordship. In the FIR, he is stating the presence of all the persons, naming all the persons. In the evidence, he comes in the chief. Nothing mentioned that they were moving ahead with the friends, Lordship. Or they were behind me with the friends.
What about the evidence of PW number 4?
Lordship. PW
Independent
Lordship,
eyewitness.
PW eyewitness, Lordship, that I claim that regarding the dead night.
Let us see PW number 4.
Yes, Lordship.
That is at page 15.
Yes, Lordship. I know the accused Aziz Ali. I know the informant. I know the deceased Jitendra Rajak. The deceased died, Lordship, at page number 15.
Yeah.
The deceased died on 15/1/13. The incident occurred on 13/1/2013 at around 10:30 p.m. At that time, I was closing my shop. 4 persons, namely Sumit Rajak, Munna Rajak, Avadesh Chaudhary, PW11, Rajak Mahato, came to my shop to purchase something.
So Sumit Raj, so who is the deceased is the Jitendra, okay?
Yes, Jitendra is the deceased.
Yes,
I heard a shout from outside my shop. Then I came out from my shop and saw Ajit stab the deceased Naresh Rajak with a knife on his stomach 3 times. The incident occurred at a distance of 30 meters from my shop.
30 meters. 30 meters. Then?
Then Aziz fled from the place. Then he ran away from the place of occurrence in a bike. Then we took Jitendra Rajak to a nearby house of Manoj Rajak and made him sit in the veranda, and then we called 108. Then the above named 4 persons also present in the place of occurrence. Then he was taken to hospital where he succumbed to his injuries. I have seen the knife which was used by Aziz. Police recorded my statement. I have also brought before the magistrate. Exhibit 4 is the statement. The road of Dubipati is ahead from my shop towards River Dike. The place of occurrence is backside of the house of Santosh Thakur. The boy's name Sumit Rajak, Munna Rajak. House is situated at left side of my shop. The road of Dubipati is less than 1 kilometer. It is not a fair depose
So what about this? So this evidence, not shaken at all.
Lordship. Regarding that only, Lordship, I will say that regarding at the dead hours, when the father's evidence is there, whether his evidence, because he is stating about the evidence of the presence of the other witnesses.
Okay,
whose
supposing
fathers-
we accept your submission, okay,
Yes.
father's evidence gone. What about PW number 4? What about his evidence?
Lordship, that I only submit that in the dead hours at, without the lights, Lordship. Electrification lights.
This
30.
person, they came to his shop to buy things.
Lordship.
At 10:30 at night, they came to buy things.
Lordship.
So everyone was moving around.
Lordship.
Then the above named 4 persons were also present in the place of occurrence.
But regarding the presence of the other 2 witnesses, PW2, PW3, from the evidence of PW10, it appears that they were not present. They were having feast. If we accept PW's one evidence, then the others' evidence whether to be believed or not.
PW10.
PW10, because PW10 states regarding PW7, PW2 and PW3 is having feast along with them. PW10
Was
is-
having feast, does not say. These are
because
all-
thereafter they have no lordship. Thereafter, if your lordship sees the
That-
next
that
line,
told us a different-
PW10. Because-
Anyway, assuming that those persons were not there, this PW4 saw it.
Then whether
PW10 is not the eyewitness.
No, no.
PW not eyewitness.
PW
No, but he says that those persons,
Yes.
they were having feast together.
Yes.
And when they heard about the news, then only they came.
then only they came.
So it appears that those persons were not there during the occurrence.
And
However, PW number 4, his statement is there, and that has not been shaken.
only one line that it has come that the distance regarding the distance from where it's
30, 30 meters. 30 meters will be what? From here, maybe 2.5 size this room.
Yes.
2.5 size this room. That is not very far.
And
Normal village people lives in a neighborhood. Accused lives in a
And-
neighborhood, my lord.
regarding PW11 evidence, lordship, who was all along present with this PWs 1, 2, and 3 and 4. They have stated that PW4 when he was there, PW11 was also present. But if we see the evidence of PW11, he says that I do not know the complainant. However, I know the accused as he is my neighbor. The incident took place about 5 or 6 years before. I had heard that accused, namely Azizur, had committed murder of some persons. Police came to our place and inquired about the occurrence. Other than that, I do not know anything. My statement were recorded in the magistrate lordship. His statement is that he
Oh,
was all along
there are
present.
164 statements also, your lordship.
His statement in the court, lordship, that is stating that he doesn't know because all the other witnesses he was also
You
present.
see, these are village people.
Lordship.
You don't expect them to know English. That is why Supreme Court has also said that as far as possible, this evidence should be taken in the language known to them.
Lordship.
Now, unfortunately, it's been done in English. I doubt whether they understand also what's being recorded.
Lordship.
Lordship, I can't say lordship.
But
because
then
now
we
what
can't
is
help
there?
it. We have got to go by what's been
What is
recorded.
there in the record?
Now, PW number 1 also, again, straight away, if you see, at page 8,
Lordship.
age about 21, 26 years. Cannot be 26 years.
Yes.
PW?
PW1
Age.
at page 8,
Yes, lordship.
age about 26 years. How can he be 26?
26 years.
Lordship. But that I leave it to Lordship, but
Unless the deceased is his stepson or something
Lordship, that
from
has,
his wife from an
yeah,
earlier marriage or
yes,
something.
that has not come, Lordship. But whatever is on record, that we
No,
have to go by the record, Lordship.
You know, a lot of
But Lordship, whatever has been come up on record, we have to go by that only. Lordship.
correct. So if we go by that, that means his friends, his son is around 22 because his friends were all around 20. His son's friends were all around 22, 25. So he and his son only 1 year age difference.
No, Lordship, but whatever evidence we have also seen, because
They must
age
have
might
been
be
good
Lordship.
friends.
Lordship, but
G-
regarding his
Lordship,
evidence,
You see, this small is
Victim is 32 years.
Victim is 32
As
years.
per PM report, he is 87.
Oh, okay, victim is 32 years.
that might be typo.
Then what happened? Then what do you say?
That
It's
might be
it's
typable
like
error,
Mr.
Lordship.
Kushwant Singh had given that joke, no? I am now my father's grandfather. You remember that joke? Given of marriage between getting married to someone else, and it's a joke. So at the end of the day, it says that his stepfather.
Yes.
I am now my father's father and grandfather.
That might be typographical error, Lordship, because 62 it might be
That is what it
26.
is, the typography. I mean, that's what I'm trying
But
to say.
regarding the evidence part, Lordship, but that cannot be said as a typographical error, Lordship. Regarding his cross-examination part, I'm relying. That cannot be a typographical, Lordship.
It is not a typographical error, but I doubt that this person knew what was being recorded. He's a villager.
Lordship.
He's a villager, and
Lordship,
it's
but
all done in
whatever is-
English. And all this entire case is about the villagers.
But
And
the
I don't
question
think
is-
they're very good in. I mean, very conversant in English.
But Lordship, whatever been stated to the witnesses, that is stated in the Assamese only. Only the writing part comes in the English, Lordship.
So
But-
while
That is
translating,
what
yes.
that is the problem. That is the problem. Whether it is translated, it is recorded as per the answers given by them, or translated as per the translators. I mean the person recording as per the way that translator wants it to be recorded.
Then,
don't know.
then we can't say, Lordship, then the whole thing has to be
No, you
changed,
see,
Lordship.
we have had there are instances where translation is done by the councils and recorded. And if the other side, the council is not very conversant in English, the other council can translate the answers in a manner that is,
Suitable
favorable
for
to
him.
him. Yes. And which the other side will have no clue about.
Lordship, but the presiding officer is sitting there, Lordship. He is
No,
viewing the
no,
things. whatever is
sometimes
stated.
have you seen in the court, sometimes there are 2-3 evidences going on at the same time. Sometimes it happens.
In our place, only one. Case
One.
was known. Lordship, I leave it to you, Lordship.
No, just a conversation. I mean, I am clearing my doubt.
Lordship.
So this is our job to clear
Yes,
our
Lordship.
doubts. And it's your duty to try to clear my doubts.
Yes, Lordship. Because whatever is there on the record, we have to go, Lordship. We can't imagine in a case of this type, Lordship, that whether he has understood or not, Lordship. Because whatever has been stated, he has been thereafter, it has to be read out because it has been after that only, after showing only, he puts the signature, Lordship. That is the thing, Lordship, because that cannot be that I do not know what has been written in the document because I am a layman.
No, but then for a normal person to say that stick is black, and then the next minute say, no, the stick is not black, it's not done for a normal person.
Lordship. But coming in the court and stating this type of things, Lordship, that he was all alone.
But
Lordship.
one thing is that you see, when he talks about the FIR, that FIR was lodged 2 years back. In fact, it was lodged, yes, 2 years back.
Yes.
So
14
he might not have remembered what was in the FIR.
Lordship. But whatever has
And
come,
so either he is lying or that FIR was not correct or whatever. And we'll see.
Lordship, I leave it to you, Lordship. My submission is that whatever has come on record, that is to be accepted as a whole, Lordship.
Correct.
Because we can't say that what was there prevailing at the court at that time.
Correct, correct. We have to go by what is there in the evidence. That's all. We cannot go beyond it.
Lordship. God bless you.
Lordship, one more judgment on your Lordship appreciation of evidence. Lordship, 2011 for SSA 324, para 25.
Para 25.
Yes, your Lordship, may I read it? In all criminal cases, normal discrepancies are bound to occur in the depositions of witnesses due to normal errors of observation, namely errors of memory due to lapse of time or due to mental disposition, such as shock and horror at the time of occurrence, where the omissions amount to a contradiction, creating a serious doubt about the truthfulness of the witness, and other witnesses also make a material improvement while deposing in the court. Such evidence cannot be safe to rely upon. However, minor contradictions, inconsistencies, embellishments, or improvement on trivial matters which do not affect the core of the prosecution case should not be made a ground on which the evidence can be rejected in its entirety. The court has to form its opinion about the credibility of the witness and record a finding as to whether his deposition inspires confidence. Exaggerations per se do not render the evidence brittle.
Can you give us?
Yes, I'll.
And madam, just look at the statement of PW number 10 under 161. That's
Yes.
all.
10 to Pinam, Rahul Raja.
PW10, Rahul Raja.
That is again in Assamese or in?
Lordship. But we have some record evidences how. Because
No,
Lordship,
161.
whatever is there in the paper, it is translated part. So court's part will be different.
No, you see, there is a problem with translated
Yes.
copies. You see, the meaning sometimes
It's in
get lost in
Assamese.
the translation.
161 is in Assamese.
In Assamese,
Yes.
what does it say?
মোৰ নাম ঠিকনা চয়নছো বৰ্তমান মই ঘৰতে থাকো যোৱা ইংৰাজী 13/1/13 তাৰিখে আমাৰ ঘৰৰ ওচৰৰ আছে জিতেন্দ্ৰ ৰজক নিজৰ দোকান বন্ধ কৰি ঘৰলৈ আহি থকা অৱস্থাত পদূলি মুখত উক্ত মুকদ্দমাৰ আসামী মহম্মদ আজিজ আলীয়ে আৰু 2-3জন ল'ৰাৰ সৈতে কথা পাতি থকাৰ অৱস্থাত জিতেন্দ্ৰ ৰজকে কিবা কথা এটা কোৱাত উক্ত মুকদ্দমাৰ আসামী মহম্মদ আলীয়ে হাতত লৈ থকা চুৰিখন. So he specifically named the Jitendra. This victim was talking
No,
along with
no, I
somebody.
want to know whether he says that he was having a feast with
Yes, yes.
Munna, Sumit,
Yes,
Babu
yes.
and Amit, and
Asami
whether
Mohammad
they.
so and so. মাটিত বাগৰি পৰে আৰু মহম্মদ আজিজ উক্ত মুকদ্দমাৰ পলাই যায়. হিমৰ যুগত জিতেন্দ্ৰ ৰজকৰ চিকিৎসা চদি মৃত্যু মহম্মদ আজিজ আলীয়ে ব্যৱহাৰ কৰা চুৰিখন ঘটনাস্থলী so and so. No, nothing. It's not there. The other persons were there.
But Lordship, whatever has been stated in the evidence, that is to come, Lordship, because
No, but then
161, whether because one person cannot be convicted on the basis of
No, no, what I'm
161.
trying to say is, you see, with the statement given under 161, that can be used for the purpose of discrediting. a
Yes,
witness,
yes, for contradiction.
For contradiction.
Yes, my lord.
Or for corroborating.
Yes.
Lordship.
Now, if that is not, if there is a contradiction or if there is some discrepancy, either we do not use this evidence at all.
Lordship, because
Then in that
as far
case, what
as
happens?
my knowledge goes, Lordship, 161 statement can be looked into or can be used at the time of to either contradiction, Lordship, or contradiction, and 164 for corroboration. And that is to done in time of
161 your
cross-examination.
lordship may always look at if your lordship desires, because your lordship sometimes they witnesses improves in the court. They do not say on the first instance in the
No, I
before the
think
police.
161 can also be used for corroboration. Can also be used for
160,
corroboration.
164 corroboration as well as contradiction.
Yes, for
And
both, for
161
both.
only contradiction, Lordship, not corroboration. Only contradiction.
161
Only for contradicting a
Not for
witness.
corroboration.
No, no, Lordship. That is the rule, Lordship. 164 for both the purposes, for contradiction as well as corroboration. And
I
for
don't know, I think it can
161
be used
only
for-
contradiction.
161 can be used for both.
161
Substantive
only.
evidence, 164. It's
Both,
not a
both do not
substantive
have
evidence.
substantive evidence, but for the purpose of contradiction, 161 can be, and for the purpose of corroboration as well as contradiction, 164 can be looked into. That law is very specific by the Supreme Court also, Lordship.
Show me that.
Lordship, right now, I'm not got that.
Tehsildar Singh's case is there.
Yes,
AR
Tehsildar courts
9050,
way back.
how the contradiction has to be proved, your lordship. And thereafter, court number 5 has delivered, 6 has delivered on judgment on contradiction.
Yes. Because contradiction and corroborations have to be put to witnesses.
Direction there.
While during the cross examination, the defense counsel can put those things by showing those things and for the purpose of hostiling a witness, then his 161 can be shown to the prosecution. That's the party who wants to contradict with those statements, Lordship.
Not Tehsildar Singh's case, my lord.
And for confirming those contradictions, Lordship, during the time of examination of the IO, those statements has to be stated whether those statements appears in the diary or not. For that purpose, contradiction, Lordship, not corroboration of 161 cannot be used. That is the difference. 164.
No, the evidence given by a witness, if it is the same as the one given in his
Substantive
statement
evidence.
Yes.
to the police,
That will be.
that corroborates his evidence.
Yes, that is the thing. But if for the purpose of contradiction, Lordship, it can be shown to the witness. But 161 cannot be looked into for corroboration, for dragging that it corroborates with some other person's witness. That cannot be used. 164 can be used because 164 having the power of both contradiction as well as corroboration. That is the difference, basic difference between 164 and 161. It can be looked into 161 only for contradicting. That look, while stating before the IO, you have stated like this or you have not stated.
And
like
so if there is a contradiction, then what
It
happens?
should be marked.
So
my
we
lord.
don't rely upon the evidence.
Yes, yes, that is the thing.
So if we don't rely upon the evidence of PW10,
Yes,
because there is nothing mentioned by him with regard to the other 4 persons
Yes.
in the statement made to the police,
but
then that evidence goes.
but that cannot be done, Lordship,
Why
because
not?
now. But,
Just now you said it
no,
should be done.
Lordship, because this has been come on evidence on that part was the duty of either of the
No,
prosecution
you
or either
see-
of the defense, Lordship.
No, you see, just now you said
Yes,
that if a statement of a witness
yes,
made under
yes,
161
Lordship.
is not in consonance with his
Yes,
evidence
yes,
given during the
Yes,
trial,
Yes.
then the evidence given by him
Look on.
is not
Yes.
reliable
Yes, because that part has
because
to,
there is a difference
yes, yes,
with
because
facts.
that job is to be done at the time of Lordship
No, but
examining him,
then can't
Lordship.
we examine it now? Isn't appeal a part of the trial?
But if that can be seen, Lordship, then because then what will be the evidence before the court, Lordship? Because that is having
we'll cut out that evidence, look at the other evidence only.
but that is not the rule because a person cannot be convicted on the basis of 161 or 164.
We're not even going to consider a 161 statement. 161 statement will go. We're not going to consider, not even his evidence. So PW number 10's evidence will have to go according to you.
No, Lordship, because that job has to be left before the trial court, Lordship, because at the
Trial
time
court.
of cross-examination, those questions
So
have
it
been put,
cannot be
Lordship.
done by us.
No, Lordship, because at that moment, Lordship, if that can be stated, that then on the basis of 164, 161, a person can be convicted, Lordship. That will be the rule then,
No, we are
Lordship.
not going to, we are going to completely forget about PW number 10's evidence because it is not in consonance with his statement given under 161. It is contradictory.
That, Lordship, because whatever he has stated before the court, Lordship, if that was the thing, then both of the parties, either he has to be declared as a hostile by the prosecution, Lordship, as it has been done with PW9, Lordship. They didn't declare him as a hostile witness, Lordship, because they have done the same thing with PW9, Lordship. Now, whatever has come in his evidence, that is the thing, Lordship, that is to be believed. How can his 161 can be taken help, Lordship, at this stage?
Who's taking the help?
Lordship, for the sake of argument, I am stating, Lordship, the rule, whatever I have learned, Lordship, that 161 can be taken for contradicting a person's evidence, either by the person.
So if we find that there is a contradiction between the statement under 161
Lordship.
and the evidence given by him
Substantive evidence.
before in the trial court, Now, what is to be done by the court? It has to discard the evidence or what?
Yes, Lordship. If it is not contradicting evidence, then by
If
the
it,
cross,
I'm
yes,
said, if it is contradicting,
yes,
then that part that is contradicting
yes.
should not be considered by the
Yes.
court.
But that has to be come on the proper way by cross-examining, Lordship. How can now it come? Because this evidence, whatever he has evidence.
But the statement is there, it has come by way of cross-examination.
Yes, because that is the Tehsildar Singh's judgment is that only, Lordship. That we have to show it first to the
Yes, to the witness.
witness.
Then it
Thereafter-
has to be marked, my lord. But what happens for the reasons unknown, sometimes the court below as well as the IO, your lordship. He does, even if the witnesses
And
say it doesn't come up on
Justice
record. my
Suman
lord.
Sam's judgment is also on that line only, Lordship. That first you have to show it to the defense,
Yes.
first you have to put it to the witness.
Witness.
Thereafter, IO should come and say that whether you have to put that question to the IO. Then IO
It has
will
to be marked, my lord.
mark because the diary is with the IO. When he will come, he will see the yes, these statements are not.
But
recorded.
isn't this?
But they don't do.
But isn't the statement of witnesses a part of the charge sheet?
161 statements are
Yeah, part of the charge sheet.
No, Lordship, it is not. It will come along with the not with the charge sheet, but
No, no,
investigation part. Yes,
I said
Yes.
it's not part of the charge sheet.
I'll check, my lord.
it will come along with the during the investigation. It will be the things which will be part, Lordship. But the judgments are very clear that it should come from the mouth of the witness, and thereafter you have to put to the IO. It cannot be taken as take away, Lordship. at
No,
this
your
stage.
lordship, the documents, like whatever is there, it's
Ah.
not there. Only one page.
One page only, Lordship. The charge sheet does not attach those things. And here, the procedure as laid down by Tehsildar Singh, and that has been followed in Justice Suman Sam's judgment also, Lordship. The procedure is that we must put first to the witness, thereafter to the IO,
So in that case,
Lordship.
the FIR which is
Yes.
submitted,
Yes.
whether that was put to the witness to
Yes.
PW number one.
Yes, because that was
Let
exhibited
us
to
see in
him.
the cross whether you said whether that question was put to the PW number one.
Lordship.
That you have stated this, that there were 3-4 persons going with your son, but then you
That
have not mentioned
particular
this in
question
your
was not put.
cross-examination. So let us see this.
Lordship,
Page 9,
cross
my
part.
Yeah.
I do not know who lost the FIR.
I don't
I
know.
also do not know the contents of the FIR.
Yes.
He simply denied, Lordship. He said, I do not know.
So has Justice Suman Shiv's judgment been followed
Where, Lordship?
to see whether that statement made
Yes, Lordship.
with regard to the event,
Lordship.
that he is now contradicting himself in his cross-examination?
No, Lordship, because in this matter, Lordship, it has been stick only to the FIR. FIR is not a substantive evidence,
What
Lordship.
about this portion?
Which
At
one?
the time of occurrence, there was none except myself and my son.
Yes. No, because he has admitted, Lordship. If a person admits, then it should not be put to the mouth of the IO, Lordship. When he denies, then only the IO will see the diary and find the statement where what is written there. Lordship, P.J. Swakia will be wherever.
I don't know, he is much aware
Yes,
than me, I
because
know.
he being the comes from the judiciary side, so he will be better knowing these things, Lordship.
Correct. But then that doesn't mean that we should also know, we should also be given assistance.
Lordship. No,
That is why we are here.
whatever I know, Lordship, I am assisting, Lordship, because the law is that.
Later on, I'm going to consult him and take
Lordship, Lordship.
his help.
Because
We're
the
going to
thing.
do it together.
Yes, Lordship.
But for the time being, I need it from you also.
Lordship. Because there is the rule, because whatever it has been come in the judgments, it has been stated that first, if you want to contradict or corroborate, then you have to put that question to the witness first. Whatever he says, if he denies, then you have to put it to the IO. He will see the diary. If it is said, yes, he have not stated, then that will be an admission. And if he denies that, yes, he has not stated, then there is of no use, Lordship. That is the thing to be seen. But regarding the FIR, how can I contradict with the IO, Lordship? Because the FIR is not a substantive piece of evidence. Whatever is to be done in the evidence part, the evidence is the substantive piece. FIR is only an encyclopedia. That is not an we contradict with the witness,
So,
Lordship.
If FIR is not a substantive piece of evidence, then the statement made therein that he was going along with his friends need not be considered. That does not have any relevance now. We'll only go by the evidence.
Lordship, because whatever is evidence.
And where is the contradiction?
No, because he has said that he was alone, Lordship, in the evidence part. If he is alone, then what about the evidence of other witnesses, Lordship? They are
Other
stating.
witnesses, they are all similar.
No, but they doesn't speak of evidence of this, that they were regarding the PW1, Lordship, because if all of them were, my submission is that, Lordship, if all those persons are there, then one person has to speak the other, Lordship. Why they were silent?
Where do they say that they were, in the other evidence, where do they say that they were going with the deceased?
Because
in the evidence of all the other witnesses, where do they say?
Lordship, 1 minute, Lordship. That is not there.
So the only thing was that the FIR stated that. But none of the witnesses have stated that those Munna and whatever, they were walking with the deceased.
Not sure.
So where is the contradiction? And all the evidence, in fact, corroborates that they were not walking together.
No, Lordship, then this part remains of his cross, that at the time of occurrence, there was none except myself and my son.
Correct.
Because the other person has said they had come.
Correct. There were none at the place near him. That's all.
Place of occurrence means the PO, Lordship.
We'll discard his evidence. Not
Because-
reliable. We'll have to take whoever the evidence of those other persons who are reliable.
Lordship, because he is very specific regarding that at time of occurrence, there was
So
none.
the only thing was that the FIR caused the problem.
Lordship.
Because in the FIR, the father has stated that these persons were walking.
Yes.
However, the evidence of all the other witnesses who are reliable witnesses, independent witnesses, does not show that anybody was walking with the deceased.
No. That is not. That is not.
I have given two judgments and Lordship, Justice Suman Sam judgment, Criminal Appeal 205/2019.
Have you given that also?
Yes. No, not that. Lordship, you may look into.
Okay. Heard. We're finished, I think.
Yes. Lordship.
Heard Mr. U. Chowdhury, Learned Legal Aid Counsel appearing for the appellant. Also heard Ms. B. Buyan, additional people. The challenge made is with regard to the impugned judgment and order dated 9/1/2020, passed by 374/2013, by which the appellant has been convicted under section 302 IPC and sentenced to undergo rigorous imprisonment for life comma, along with a fine of rupees 20,000, comma, in default, to undergo simple imprisonment for 6 months. Full stop. Next paragraph. The prosecution case, in brief, is that the informant bracket father of the deceased submitted an FIR dated 14/1/2013 to the in charge Amola Patti Police Outpost, Dibrugarh, stating that at about 10 p.m., while his son Jitendra Rajak was coming from a shop with his friends Viz Sri Raju Mato, bracket PW number 6, comma, Munna Rajak. No, it'll be Raju or Rajiv? Raju Mato, okay, Raju Mato, or PW number 6, comma, Munna Rajak, bracket PW 3, and Sumit Rajak, bracket PW number 2, comma. The appellant Aziz Ali, along with 2 unknown associates, attacked his son with deadly weapon, comma, that is iron rod and dagger. Full stop. His son was stabbed 3 times in his belly and stomach, due to which he sustained grievous injuries and eventually died in the Assam Medical College and Hospital on 15. Don't say that. Don't say that. And for which he was admitted to Assam Medical College and Hospital. Now, pursuant to the FIR, Amula Patti. Pursuant to the FIR, Dibrugarh PS case number 45/13 under section 341/326/506/307/34 IPC was registered on when? On
14/1.
On 14/1/2013. Full stop. The informant's son expired on 15/1/2013. After investigation was carried out, and charge sheet filed, the appellant was the learned trial court framed a charge under section 302 IPC against the appellant. The appellant pleaded not guilty and claimed trial. In the trial proceedings before the learned trial court, 13 prosecution witnesses were examined. After the appellant was examined under section 313 CRPC, the learned trial court came to a finding that the appellant was guilty of the offense under section 302 IPC and was accordingly convicted under section 302 IPC. By the impugned judgment and order dated 9/1/2020. Passed in sessions case number 374/2030. The learned legal aid counsel submits that the statement of facts provided in the FIR dated 14/1/2013 contradicts the evidence given by the informant bracket PW number 1 during cross-examination. And as such, the evidence of PW number 1 cannot be considered, could not have been considered by the learned trial court for convicting the appellant. He submits that in the cross-examination, the PW number, the informant bracket PW number 1 has stated that he did not know who lodged the FIR and or the contents of the FIR. He also denies the contents of the FIR to the effect that he was going along with his son at the time, along with his son just prior to his son being attacked, allegedly attacked by the appellant. He also submits that the informant having stated in his FIR that he also submits that while the informant in his FIR had stated that PW 2, 3, and 6 were walking along with his deceased son at the time of occurrence, in his cross-examination in the trial court, PW number 1 has stated that there was none at the time of occurrence except the informant and his deceased son. Next paragraph. The learned legal aid counsel submits that the evidence of PW number 10, which is to the effect that PW number 3, 2 and 3, which is to the effect that PW number 2 and 3 were having a feast in the paddy field near his house, and that they came out on the road only after hearing that the appellant had assaulted the deceased, goes to show that PW number 2 and 3 were not walking with the deceased at the time of occurrence. At time of occurrence of the incident. Full stop. He thus submits that, full stop. He further submits that the evidence given by, where is that light? He submits that the evidence given by
Light but
that light
prosper. PW2 lordship prosper.
evidence given by
Electric light.
PW number
2, my lord.
2 lordship
Two.
cross.
Page
There
11.
were electric light lighting in the electric post as well as in the shop. That part lordship.
is to the effect that there was no electric light
There were electric lights.
There were electric lights.
Page
Lordship
11.
at the street.
There were electric lights.
Lordship. My submissions was that lordship.
There were no electric light, but he said there were electric lights.
Because from the sketch map also it were not shown because other things were shown. Lordship.
He submits that though the evidence of PW number 2 and 3
And it
is to
could not
the
be
effect that-
demolished, my lord.
Huh?
He repeated further. It is not a fact that at around 10:30, there was no electric light in the street and the shop. It's not a fact.
Ah.
Could not be demolished.
He just he submits that though though PW2 and 3 had not denied the suggestion, had denied the suggestion that there were no street lights on that particular night, the sketch map of the place of occurrence does not show the location of the street lights. He accordingly submits that the incident could not have been seen by PW number 2 and 3 in the absence of any street lights.
10:30.
Huh?
At the time 10:30 at night.
At the relevant time, which was 10:30 p.m.
From a distance of 50 to 60 to
So
70.
further, the distance of PW2 and 3 being around 50 to 60 meters from the incident, they could not have seen the incident. Anything else? That's all.
Regarding this point.
Huh?
Regarding this point, regarding the electric.
Yes.
light.
Any other point? What is the other point? Full stop. Next paragraph. The learned legal aid counsel also submits that while the witnesses have stated that they saw the appellant stabbing the deceased in his belly, the doctor's report shows that the injuries sustained by the deceased pertained only to the chest area, chest and back area, and not to the area around the belly. He also submits that the inquest report dated 15/1/2023, which has been exhibited as
Exhibit 6.
Exhibit 6,
Exhibit 6.
is inadmissible as evidence in terms of Section 61 of the Indian Evidence Act 1963, inasmuch as the maker of the said inquest report has not been examined by the learned trial. He accordingly submits that due to the discrepancies in the evidence of the prosecution witnesses, the impugned judgment and order should be set aside. And the petitioner and the appellant should be acquitted. Ms. B. Buyan, additional PP, on the other hand, submits that the submits that there were 5 eyewitnesses to the incident wherein the appellant had stabbed the deceased. Further, the further 14/1/2000 for further 14 January being celebrated on the occasion of Mag Bihu every year, it is a time when old and young are out in the streets for late at night. Full stop. She submits that the evidence of the witnesses clearly show that the street lights were on in the village at the time of the incident, and as such, there would have been no problem for villagers to see and recognize each other, even at a distance of 50 to 60 meters. She, however, submits that PW number 4's evidence, who states that he was around 30 meters away, clearly shows that the appellant had stabbed the deceased. She also submits that the evidence of PW number 4 has not been shaken by the appellant. Full stop. Just let me skip 2 and 3. Two does not talk about 50 meters.
Lordship, 2. Lordship, PW2's evidence at page 10, that when we returned from the shop, cross about 50 meters, we heard
When we cross 50 meters, does not say that from a distance of 50 meters. So whatever I stated before that.
PW3 is stated regarding the 60 to
Maybe.
70.
No, either this street lights were at the time, at the time were open at the time of full stop. She also submits that the evidence of PW number 3, that he saw the incident from a distance of 60 to 70 meters. During his cross-examination cannot be disbelieved. Full stop. That's all. Can you carry on with what I've said? The additional PP submits that when there are 2 sets of evidence, is it 2 sets of evidence?
No, like medical and ocular.
When there are medical and
Vis-a-vis
ocular
ocular.
evidence which are contradictory to each other, is it?
Yes, then
Which are not in consonance with one another, the ocular evidence will prevail
Yes,
over the medical evidence.
yes, my.
Full stop. In this regard, she has relied upon the judgment of the apex court in the case of so-and-so was so-and-so reported in 2014, 13 SCC 308, bracket para 8 and 9. Full stop.
Abdul.
She also submits that minor contradictions, inconsistencies, embellishments, or improvements on trivial matters which do not affect the core of the prosecution case should not be made a ground on which the evidence should be rejected in its entirety. And in this regard, she has relied upon the judgment of the apex court in the case of State of UP versus Naresh and others reported in 2011, 4 SCC 324. Full stop. Then Justice Shuman's judgment on what
Given,
ground?
Lordship.
On what aspect?
The contradiction part, only how it should be proved. It may not be, it's not may not be relied upon.
Which para?
I don't remember the paragraph.
You want me to
How
read
it
the entire judgment? I will read it, but then for now I need the.
No, Lordship, contradiction, how
portion.
it has to be proved, my lord, it's there. I was only there in that case. Need to be like.
Where?
It is there, your lordship. It may not be relevant for this case.
We'll make it relevant.
For the sketch map also, I have got a judgment. Faulty preparation of sketch map. I got one judgment, good, my lord, 2019, 12 SCC 1.
In respect of, no, the learned addition, the PP also submits that the mistake in the sketch map in not showing the location of the street light by the IO would not be fatal to the prosecution case.
Yes.
In view of the judgment of the apex court in so-and-so versus so-and-so reported in
2019, 12 SCC 1. Para 75. May I read it once, my lord? It was submitted that on the basis of the statement of PW 55, sketch number so-and-so was prepared. There is crucial variance with the description recorded under 161 CRPC. The descriptive features mentioned by him are not even reflected in the sketch. PW 55's deposition cannot be discredited or tainted in any manner by faulty preparation of sketch. Even otherwise, the evidence of sketch is not of much significance. Sometimes the sketch may not tally with the version given by a witness.
But in this case, there is the issue of this street light has only been brought out in the cross-examination.
Yes.
That's not relevant. Anyway. Anyway, okay, I do not know. I'll have to look. Just say one paragraph. Just say paragraph within paras. Justice Suman's judgment. Just I'll look.
And I have given the Tehsildar Singh's judgment also
Huh?
for contradiction.
Contradiction and corroboration.
What? For what contradiction?
Lordship, just wanted to have a look. Tehsildar Singh's case, my lord, how the contradiction has to be proved, my lord.
Oh, yes, yes.
I have
So when
given,
that?
I think that book has been brought. It's a big book. No, not this one, big one.
Big. Full judgment.
Very old judgment of 1950s, my lord.
Just write, huh? And, KIR 1959 SC 1012. Okay, this is it. How many pages is this?
It's a big one, Your Lordship. It is the authority as regards contradiction.
Thank you for giving me this homework.
Obliging.
Hearing concluded, judgment reserved.
Obliging.
লৈ যাব লাগে